be heard. God bless the great state of Ohio and this honorable court. You may be seated.
Good morning. Welcome to Lawrence County Municipal Court. I'm Judge Capper. We have some reviews to do for people who have been in court ordered to do things, and this is a check on whether you're making progress on what you're ordered to do. So if you're here for that, your name's going to be called by the bailiff, and when it is called, come up, and it'll be in a group. Come up with the group to the table to your right, stand there. If you think you should have been called and didn't get called, go check in with the clerk. And if you missed a hearing, you were set for review on a prior date, you're not going to get called with this group. You'll get called later with the arraignments, and you need to let the clerk know you're here if you missed a hearing previously. Call the first case.
Denise Faulkner, Wayne Gullett, Ethan Mitchell, Richard Wright, Mitch Wright.
All right, Denise Faulkner is here. And we have a report for her.
Denise Faulkner.
Well, it looks like there's still work to do. You missed the very first
Yeah,
session.
that was lack of communication because Kathy's phone wouldn't call mine, but she said I had it blocked and I don't.
Yeah, I went to pick her up, Your Honor, and I tried to call her like 4 or 5 times, and I couldn't get a hold of her.
She wouldn't answer.
No, but when I called private, she did pick up.
Okay.
Also, Your Honor, I'm working a full-time job and they got me going every day. And Becky was going to come today, but she got COVID and she was going to let you know that. And I'm also, you know, I haven't done anything. You can take a urine screen.
We are looking for her another job because that is where she consumed the THC, was at her employment, she told us.
And I have been looking for another job.
Okay. Well, there's still work here to be done.
Yes, sir. I have been going every day, every morning after I got off work.
Will that continue for a while, or how?
It's usually like that for 30 days, and then
This
it's
is in intensive outpatient, right?
Yep.
Okay.
I'm willing to do that, Your Honor.
All right. Well, it seems like there's a little better progress than before, so let's keep going.
Okay.
I'm going to set you for September 5th, and that'll be a Tuesday,
Yes, sir.
because there's a holidays on the 4th. So September 5th will be your next review at 9 a.m.
Yes, sir. Thank you.
You are. Wayne Galt, 21176 and 21645. Okay, looks like you're almost finished.
Yeah, I'm scheduled to take the OVI class to September 21st through 24th.
Okay. I'll set your next hearing for October the 6th. If you get a completion on that and pay off, you have just a small amount left on your fine.
Shouldn't.
I'm showing $80. Is that long? Let's pull it up. It's on 21176. That was what I'm showing.
It doesn't show anything.
Doesn't show the fine, or the,
When I get the amount owed, it doesn't show anything.
I have the receipts at the house, it should be paid in full.
okay. I want you to go check in with Mr. Major and let him check it. On my printout, it's showing $80 left.
Okay, when I pull it up this way, it does show $8.
Yeah, okay.
I'll pay that now.
All right. If you get everything finished and your dip school report's good and filed with the court, you don't have to come back.
All right,
October 6th, 9 o'clock.
thank you.
You're welcome. Letha Mitchell, 2156. RRS. Okay, based on what I see in the report, I want you to do urine screen here. So
Okay.
go do urine screen and I'll have you back.
Thank you.
You're welcome. Richard Reif, 19-218, 1347. Amended reads. Okay, based on what I see here, I want you to go do a urine screen.
Okay.
Mitch Wright. Oh 08-1383 and 08-2919. Okay, you still owe 10 hours of community service and comps.
I
Your
just
Honor,
turned 20 hours in the day.
He turned in 20 hours of community service that he'd done this past time.
Okay,
10 hours will go toward his community service and 10 hours will go toward his fines.
all right, very good. Set your next hearing then for September 22nd. September 22nd, 9 o'clock.
Danielle Summers, Donald Dickus, Nolan Exline, Shauna Turner, Christopher Blake.
Danielle Summers, is that RRS?
Yes, sir.
Okay, it's a very good report. This is the best one you've had for quite a while. So,
Thank you.
good job. All right. Can you pay anything on your funds?
Paying 40 today.
Okay, see the clerk to make that payment. I'll set your next hearing for September 29th.
Thank you.
Okay, good job.
Thanks.
9 o'clock, September 29th.
Thank you. Thanks.
Nolan Exline. Nolan Exline was called, he's done his community service, but has not paid fines. So the do a bench warrant. Donald Dickus, 23-104 and 105. Is that Bethesda?
Rule book, yeah.
Okay. There was an incident with drinking when it presented to
For rent.
services for Bethesda, so I wanted to do, I think it may be short on some of his screens too, so I wanted to do urine screening today.
Okay.
So do urine screening. Your name, sir?
Christopher Blake.
Christopher Blake is 23-440 and 18-357. You did turn in some community service. I'm showing you got 1 day left. That sound right?
Yes, sir.
Still has some fines to pay. Do you have a payment on your fines today?
Yes, $40.
Okay. See the clerk.
Okay.
Make your payment, and September 22nd will be your next hearing.
September 22nd,
Yes, sir.
9 a.m.
Yes, sir.
Thank you, Your Honor.
Okay. Shauna Turner is 23-227, and she's appearing by teleconference. And where are you now, Ms. Turner?
I'm in Cincinnati.
Okay. You went to the counseling center for a while, right?
Yes.
Okay.
I completed the 90-day program yet.
Okay. I need to get a report from them about that. So what's going on with you now? What are you doing? Are you working? What's going on?
Yeah, so I've been working at Planet Fitness for 3 days now.
Okay.
This is like the first job since I got out of here.
All right. And where, are you living with family or?
No, it's like it's kind of like a separate living that they like to call it outpatient. And I had my counselor write a report. I remind her yesterday, I had called another tax company and sent it to her. She said she was going to write a report.
Oh, she's going to send it into the court today then? I need to see that. We'll check it. I haven't seen it yet.
Okay, I can call her and
Do you have a report on Shauna Turner?
I haven't seen one, Your Honor.
Okay, all right. Okay, we'll be looking for that report. I'll set your next review hearing for September the 15th. And I need a report from the counseling center also. That you can. All right, September 15th will be your next hearing, 9 o'clock.
all right, thank you.
You're welcome.
State of Ohio recalls Letha Mitchell, case number TRC 2156A.
Okay. Well, you were negative for everything but alcohol, so.
I just did community service yesterday. I turned in those hours, and I'm going to be paying on my fines today at 1.
That is correct.
Okay, continue with your sessions at RRS. And how much are you paying today?
Probably 40.
Okay. And did you say she turned in?
Yes, she turned in a day of community service.
Okay. All right, continue with your counseling. And you know about the screen today?
Yes, sir.
Okay, so you'll put that in our file.
Yes.
All right, I'll set your next hearing for September 22nd. 9 o'clock.
Thank you.
You're welcome.
State of Ohio recalls Richard Wright, case number CRB 19218.
Okay, you got a good screen? Thank you for that.
You're welcome.
All right, continue with amended reads. It looks like you've missed some appointments there, so get that caught up. I'll set your next hearing for September 22nd. Are you paying anything on your fines today?
I did just a little bit ago, Your Honor. I did it over to, my wife did it online, just about
Okay, how much? Because
25.
That won't show up till tomorrow.
25. When did you say next court date was?
September 22nd. 9 o'clock, September 22nd.
All right, thank you.
You're welcome. That finishes the reviews. We'll do arraignments next. So if you're here and you have a new case, you're going to get called. If you missed a hearing or didn't do something and got a warrant on an old case, you'll get called with fees. You have a right to remain silent. You don't have to say anything. If you choose to make statements, it's all on the record. Everything here is being recorded. So what you say can be used against you if you admit something about your case. You have a right to have an attorney. If you're facing jail and you can't afford an attorney and meet the guidelines, I can appoint a lawyer for you. You have a right to bail. You have a right to make the state prove any charge beyond a reasonable doubt. Those are the rights that all defendants have. If you enter a guilty plea or a no contest plea, you're waiving those rights. You should not do that if you don't understand the proceedings, if you want to talk to a lawyer, or if you want a trial. If you don't know what to do, you should enter a not guilty plea. That's always the safest plea. It preserves your rights. Only enter a guilty plea or no contest plea if you understand what could happen and you're sure that's what you want to do. Call the first case.
State of Ohio versus Ashley Burton, case number TRD 231075.
Stand behind the table, please, ma'am, to your right. And you're Ashley Burton?
Yes.
It's alleged that you were on August the 9th at 5:39 a.m. driving a vehicle in Fayette Township with a suspended license. That's a first-degree misdemeanor. The maximum penalty is 6 months in jail and a $1,000 fine. Do you understand the charge?
Yes.
Do you understand your rights?
Yes.
How do you plead?
Not guilty.
Do you want a lawyer appointed to represent you? Do you have a job?
Yes.
What do you do?
CNA.
I don't know what that means.
Certified nurse aide.
Are you paid by the hour?
Yeah.
How much per hour?
Depends. About 14.
Are you working 40 hours a week or a different amount? 40? Do you have children?
Yes.
How many?
3.
Okay, you're qualified then. I don't have to do the math. Mr. Steyer? I'm going to appoint a lawyer for you. Mr. Steyer, he is here. We'll get him in the courtroom and introduce you. Mr. Steyer, this is Ashley Burton. It's a first-degree misdemeanor driving under suspension. Entered a not guilty plea for her. She can sign a $1,000 signature bond.
I'm going to bring this up before you decide.
I'm looking at September the 15th or after for a pretrial.
I'm available the 18th and 18th through the 29th.
Let's do the 18th. September 18 will be the pretrial, and that's going to be at 10 a.m. October, please.
State of Ohio versus Allison Snyder, case number TRC 23-1100, A, B, and C.
Ma'am, are you Allison Snyder?
Yes, sir.
Ms. Snyder, the state's alleging that on August the 11th of this year at 4:30 a.m. in Fayette Township, you were driving a vehicle while you were under the influence of alcohol or drugs or a combination of those substances. And they're alleging this would be your first conviction if you got convicted. So on a first offense, the maximum penalty you face is 6 months in jail, $1,075 fine, and a 3-year license suspension. That's the most the court can impose. The least the court can impose, there is a minimum. Most charges don't have a minimum, but this is one of the ones that has a minimum. I'm not allowed to go below if you're found guilty. The minimum is 3 days in a treatment program, $375 fine, and a 6-month license suspension. The state's also alleging that you submitted to a urine screen. So those go to a lab, crime lab in Columbus, and it takes a while to get the results. I don't have results today, and I won't have results for several weeks.
I do have my own as well.
You're also charged with not wearing a safety belt. That's a mandatory $30 fine if you're found guilty. And failure to stop at a stop sign. That's a minor misdemeanor. The maximum penalty is a $150 fine. So you have 3 charges. Do you understand them?
Yes.
Do you understand your rights?
Yes.
How do you plead?
Not guilty.
Do you want a lawyer appointed?
Please, yes.
Are you working?
Yes.
What do you do?
I take care of my mother full-time. I'm a live-in caregiver.
Are you paid for that?
Yes.
How much per hour?
$1,200 a month.
Okay. Do you have anyone you're supporting with that salary?
2 children.
Okay. You're eligible for court-appointed counsel. I'll appoint Mr. Stratton. I'm entering a not guilty plea for you. Mr. Stratton is here, so we're going to have him come in the courtroom so we can meet.
Okay.
Mr. Stratton, this is Allison Snyder. First offense OVI with a urine screen. That's the main charge. So you can sign a $1,000 signature bond. As long as you come to court, you don't have to pay that money. And I'm setting cases for September the 15th.
Yeah, you said it was a urine case and?
Yeah, so it's going to be, we'll need to go out several weeks. So
Yeah, we need to go out, probably a little bit further than that, Your Honor.
How about October 20th?
Yes, that'll work.
October 20th will be the next hearing. It'll be a pretrial at 10 o'clock.
I got this for you.
Not guilty, please enter.
Yes. All right, thank you, Your Honor.
You're welcome.
State of Ohio versus Chad B. Campbell, case number CRB 22-814, TRC 22-2782.
You're Chad Campbell.
Yes, Your Honor.
It's alleged, Mr. Campbell, that you missed a review.
Yeah, it was Monday. I had just got out of the OVI school on Sunday, and I thought it was today.
Okay. Which one did you go to?
The one up in Portsmouth.
Okay. All right. You still owe fines and costs and 30 hours of community service.
Yeah, I was gonna pay a little bit on my fines today.
How much are you paying?
$500.
Okay. And you got 5 days of community service to do. When can you do that? You can work any day, but Sunday or a holiday are the only days we don't really have community service.
I can do it any day, pretty much.
Okay. So you're going to be out tomorrow?
Yeah.
Okay. Mr. Cooper will be looking for you. He'll be here tomorrow.
What time do I need to be here?
7:30 a.m.
Okay.
Set your alarm. Get out, brush your teeth, and come right here.
Yes, Your Honor.
Wash your face, too. Probably a good idea. good training, get up early. So you need to set your alarm. Where do you live?
Colgrove.
Okay. Probably need to get up at 6:30. Little advice, I mean,
Yeah.
eat something, come here, do your community service. Okay, I'll set your next hearing. This was your first review, so I'm going to set it for October the 6th will be your next hearing. Once you finish everything up, you can quit coming to these hearings. October 6th, 9 o'clock is your next hearing. Okay, Mr. Cooper will be looking for you tomorrow.
Yeah, thank you.
You're welcome.
State of Ohio versus Branson Johnson, case number CRD 21795.
This was a case set for hearing on the 14th, so that was Monday. He's at New Life Recovery.
Yeah, 'cause, last time we talked, I was in jail, and you told me just to comply with Ironton.
I'm reviewing your report. You have a case in common pleas too, or?
That's what I'm there for. Remember, I talked to them, and you said just to comply with them. That's why I didn't know I had another court date. I didn't think about it, because I asked at the end of the thing, I was like, are we done? I didn't.
Well, you had a theft conviction here.
Yeah. And I set up where I can do the rest of my community service Monday. Well, I didn't set it up, they did. And I paid them a little bit on my fines today.
How much are you paying on your fines?
I'm not for sure how much he took off the card. At least 20.
All right, see the clerk and make that payment.
I did, and it said the computer was down. I did it this morning. It said the computer was down, but it went through the third time I did it.
Okay, well, I won't have a record of that till tomorrow.
All right.
So how often do you have to report in common pleas?
I'm not really for sure. He said as long as they send reports to him every week, drug screens and, what's that called?
Your Honor, if I may, Trish Dameron called me this week and told me he missed a review with us, but he was in court down there. So I believe they're keeping a pretty good watch on him.
Okay, well, I'll give you a couple months. Since common pleas is watching you, I won't have you in here. Usually it would be every month, so I'll make it 2 months.
Now, me doing my community service over here in Chesapeake at the, what's that food place? Does that count for my community service here?
You have to do it here or get permission to do it someplace else, so.
So who would I get permission from to do it?
This gentleman right here, Mr. Cooper, or your probation officer, Mr. Major. I'll set your next hearing for October the 16th. 9 o'clock, that's a Monday. Continue with your counseling as you have been.
Thank you.
You're welcome.
Thank you, Your Honor.
You're welcome.
State of Ohio versus James Conley, case number TRC 222720, A, B, and C.
This was set for a review hearing on the 11th, a week ago. It's on OVI. And you were not here then? Do you have an explanation for that?
Yeah, if I may, I just had hernia surgery 2 days ago, and my wife called in and tried to reschedule my probation appointment because it was the day after my surgery, and that's when I found out that I had a review hearing. I didn't know that I had a review hearing.
Okay, well, it's right on your judgment entry. I'm looking at it now where you would have been given a copy of it. It says you got a review hearing August 11th.
I'm sorry. I got all my stuff in the storage up here. I just moved back to these apartments behind Southern Hope right there.
Okay. All right.
I lost that somewhere in my storage. I apologize about that.
So are you not working now, or?
Not at the moment, no. I've got to rest
Still under
up.
doctor's care? When do you think you'll be released?
this says, like, I should be good in 2 weeks, but it could be
Okay.
longer than that.
Let me see what you got.
All right.
Okay, it does appear that he had a medical reason for missing. Okay, so I'll go out a little bit. This was your first review hearing anyway, so I'll give you more time so you can get healed up and get your community service done. Let's go 2 months instead of 1. You've got 48 hours of community service to do.
All right.
So October 20th is going to be your next hearing. Write that down. October 20th, 9 o'clock. Once you're able to work, you can come here any Monday through Saturday at 7:30 to do community service. Except, well, September the 4th, which is a holiday. So any day, Monday through Saturday, except a holiday.
Okay.
Okay? October 20th, 9 o'clock is your next hearing.
All right. Thank you, sir.
You're welcome.
You have a good day.
You too.
State of Ohio versus Bridget A. Ellis, case number CRB 1920, CRB 18235, CRA 18171, CRB 16133. Bridget Ellis.
She's here, but she's outside. You want me to go grab her?
No, she'll go to the end of the document.
State of Ohio versus Aaron Cron, case number CRA 19288.
All right, this is another case where you missed the review hearing August 11th, a week ago.
Yeah, I called Mr. Major and told him that I was sick. He just told me to come in today.
Okay, you did a day of community service since your last hearing. You have a payment on your fines.
Yeah, I'm gonna pay $20 on it.
Okay.
Your Honor, he was here today.
Okay, good. And okay, that finishes up your community service. You're done. Okay, make your payment with the clerk. And September the 22nd will be your next review hearing.
All right, thank you, sir.
You're welcome.
State of Ohio versus Jessica Leggett, case number TRD 211157. A and B.
Review hearing set for Monday. You're here today.
Yes, sir.
Do you have an explanation?
I just went to work and didn't, after group, and didn't think about it.
Okay.
Forgot.
You're at Mended Reeds.
Yes.
Okay. Is there anyone from Mended Reeds here today? I got a report on some other folks.
I graduated and I'm in community now. I'm doing the outpatient community.
With them or?
Yes.
Okay. This last report I have does not tell me that you're graduated. When did that happen?
On August the 8th.
Your Honor, I can call and confirm if you'd like me to.
Yes, that'd be great. All right, just have a seat and I want to get a confirmation that you did complete. I'll recall you.
State of Ohio versus Adam E. Daniels, case number CRB 20658, CRB 2260.
You're Adam Daniels?
Yes, sir.
Okay, you missed a review hearing in May of 21.
Your Honor, I was in prison at that time, over here in Belmont. I think Wolford
When did you get released?
June 26, 22.
Okay, and why'd you come in today?
Because I'm in drug court in West Virginia. And they want my PO's firing. She wanted me to come over and take care of it.
Okay, which drug court are you in?
Howard.
County?
Yeah, Cabell County.
Judge Howard?
Yep.
Okay. Well, that's good. You need to clean up past problems. So I'll withdraw the warrant since you came in. Here's what I'm showing. On the one case, 2658, you owe $210. On 2026, you owe $185, of which $141.96 was restitution. So, you start making payment. Are you making any income now? Are you working at all?
I'm in classes over there all day.
Okay.
So I
Well, we'll work with you. I want you to getting clean and in recovery is a priority, but you also have to take care of this stuff.
Correct. Yeah, I'm still in phase 1 over there. I just got out like 3 weeks ago, so.
You just started 3 weeks ago?
Yeah.
How long will that take before you be able to get it?
4 months.
Okay, I'll set you for October 20th also for another review hearing. I want to make sure you're still in the drug court and still doing what you're supposed to. And then I'll work with you as far as getting this stuff.
Do they do anything on the weekends over here?
Yeah, you can do community service on Saturday and I'll give you $50 a day credit toward your funds.
All right, we probably work something out like that.
Yeah, come over and do that. Now, the restitution you actually have to pay because
How much
you
was
did
it?
community service doesn't help anybody on their restitution.
How much was the
It was
restitution?
$141 and some odd cents.
41. All right.
Okay, October 20th is your next hearing at 9 a.m.
All right, thank you, sir.
You're welcome.
State of Ohio recalls Jessica Leggett, case number PRD 211151 A and B.
Your Honor, I did get a hold of Brandon Peters, the court liaison with Minute Reads, and he did confirm that she successfully graduated on August 8th. She is in outpatient services and she has been compliant since she graduated.
Thank you for that report.
You're welcome.
And you're working now, or?
Yes, I am working. I work at Subway.
What, does your schedule vary, or?
Yeah, it does.
So it doesn't matter if it's a Monday or Friday when you come back?
No.
I'll make it September 29th, 9 o'clock. That's a Friday. Okay, we've got some arraignments. I assume we're doing at the jail and other hearings by teleconference.
State of Ohio versus James Childers, case number CRB 23483A and B, CRB 22816, and Grant McCroll is on deck.
All right, sir, you're James Childers?
Yes, sir.
All right, Mr. Childers, I think you told me when I arraigned you on these charges that you wanted to hire your own lawyer, but obviously that hasn't happened.
Sir, unfortunately, I was in a mental crisis last time I saw you, and that's correct, yes, sir.
So,
sorry about that.
Would it make more sense now for you to have a lawyer appointed, or how do you want to proceed?
Yes, Your Honor, please.
And you're not working at all?
I do have a full-time job, hopefully. I was hoping to already be back there. Like I said, I was in not a good state last time we saw each other.
Where do you work?
It's called Valley Health Services. I do IT work for all their locations.
Okay. The Valley Health that's in Huntington?
Yes, sir. And there's one in Cold Road.
How much are you paid to do that?
I make about $54,000 a year.
Why couldn't you post a bond?
I don't particularly remember getting a bond, and couldn't get a hold of anybody to come post it for me. I don't have a record, so this is all new to me. I don't know how to do any of this. Sorry.
Because, I mean, if you go back to, you're actually probably making too much money for me to appoint a lawyer for. Do you have children? You do
Yes,
have
sir.
children, right? 3?
Yes, sir, 3.
Okay, I'm going to provisionally appoint a lawyer for you today, and because I know you haven't worked for what, at least a week.
Correct, yes, sir. Thank you.
And then we may have to rethink this if you're able to go back to work. You may not even have a job anymore.
Correct.
I'll appoint Mr. Smith. That probably is here. Right, Mr. Smith, I'm going to appoint you this.
Yes, sir.
So let me, and I don't know if Mr. Childers knows this, but he has children. There's a children's services case involving them. The children are now placed. That's with someone who I think is either a family member or
godparents.
Godparents.
Yes. I spoke with the Children's Services yesterday. I'm aware.
Okay. And I had set a $2,000 cash or surety bond because he had failed to appear previously on a traffic matter, and apparently he didn't post bond. Do you think if you talk to a bail bondsman and on a $2,000 bond, typically it's going to cost you $200 to get out? Do you think you can post that bond?
Absolutely. Absolutely. I could even do that today.
I can call Mr. Sowards and
Okay,
put him in touch with him.
we'll get a bail bondsman to come talk with you and hopefully make those arrangements. I have to have you post a bond because things have consequences, folks.
Absolutely.
If you get cited into court and you don't show up, well, the next time, you're going to have to guarantee your appearance because you've shown you're not reliable in coming to court when you're allowed to come on your own. And that's what's happened to you. So you need to post a surety bond, because what will happen now if you don't show up, you're going to have somebody tracking you down that doesn't want to pay the $2,000 to the court, and that makes them pretty motivated to find you.
Yes, sir.
Okay, so I'm going to take it Mr. Smith probably would like to have a phone number where he can reach
I
you.
would, Judge, yes. You have a phone number I can call you when you get out of jail?
Oh, yes, sir. Sorry, I thought you meant right now. It's 681.
Okay.
373.
373, yes, sir.
2290.
2290. 373-2290, area code 681.
Correct. I got another number as well.
We'll go ahead and give it to him if you've got it.
740.
Okay.
302.
Yes, sir.
3294.
Okay. Which of those numbers is better? Which is actually your number? Are they both yours?
Yes, sir.
Okay. All right.
So one's a landline, one's a cell
That's what
phone.
They're both cell numbers. One's just I use for work and then one's more personal.
Okay. You feel confident you can post that bond though today? 200, 250, somewhere in that range? Okay.
Absolutely. Yes, sir.
Your Honor, if I may, I believe Mr. Sowers contacted him last Friday also. His bond said $2,000 last Friday also.
Okay, you don't remember talking to a bail bondsman last week?
No, sir.
Seems like our memory is that his thinking and what he was saying was a little confused last week.
Apparently so.
And also, Your Honor, we're going to ask for protection order. We have one prepared.
Okay, I think I already, let me check. I thought I already entered one. Yes, there is an order of protection involving Charity Pauley.
That's the alleged victim.
Okay, you're ordered to stay away from her. You're not to go around her, contact her. You understand that?
Yes, sir.
Do you have another place to stay other than with her?
I will figure that out. Absolutely.
Well, I'd like to know where that would be. Where would you be staying if you're not staying?
Sure. Sure. It'll either be at my sister's or outside somewhere. I mean, I intend on,
What's your sister's name?
Amanda Childers.
And I have an address for you in Idle Acres, Huntington, is that correct?
Well, that was my latest. I had moved in with Molly down there on Township Road 1213, and then she changed the box last week. That sort of changed as well.
Okay, well, you have to stay away from her. You're not to contact her, post things about her, contact her by social media, anything like that. Do you understand?
Correct, yes, sir.
And then, so when do you want to come back, Mr. Smith?
Judge, I'm here the next 2 Fridays, and I'm not back until the 15th of September, the first 2 weeks I'm...
If you're sure you're going to get out of jail, I'm going to set it for September 15th. I'm sure you're going to get out of jail, Mr. Childers.
If it were up to me, I would already be out. I'm not sure I understand the question, Your Honor.
Well, some people tell me they're going to be able to post bond, then they can't post bond, and then they wound up sitting in jail. But you're pretty confident that you can come up with the money to post bond.
Yeah, it's just that I don't have anybody outside of here that can, you know.
Well, you do now. You've got Mr. Smith.
Yeah, I can talk to Mr. Sowers to put him in touch with you, explain the situation. But you're looking at $200, $250. You think you have that kind of money?
Yeah.
Okay.
Today was my payday, so I've got that money sitting in my account. So.
Okay, I'm going to set it for September 15th, and
Yes, sir.
if you would talk with Mr. Sowers if there's a problem with the bond, then I'll schedule it closer in time.
Okay, yeah, I'm here the next 2
Your Honor,
Fridays.
one other thing, because of the fact that there were indications that were children involved, we, of course, at the court's direction, asked Children's Services what their involvement was, and that's already been addressed. However, I also have an indication that they're not his children. So I wanted to clarify that for our record.
They absolutely are my children.
Okay.
Absolutely, they are my children. The issue with the court needing to be involved has been stemming from their mother that I'm in the long process of getting divorced from, and her not being able to come take, proper custody while I've been in jail. I've just needed help during this divorce, and I'm finally able to now get it with them being in the home where they're at right now. They couldn't be in a better place right now. So thank you for that.
There is a Children's Services case in Lawrence County, is my understanding.
Yes.
Yes, sir.
So that is independent of what we're doing, but of course I want to be aware of what's going on with them. And you're not to interfere, I'll just make it a condition of your bond, you're not to interfere with what they're doing on your custody. In other words, they placed your children, you have to respect that. You can't go demand return of the children. You have to work through Children's Services. You understand that, sir?
Yeah, I'm actually being part of that case as well this morning. They've involved me.
All right, September the 15th will be the next hearing. 10 o'clock, September 15th.
State of Ohio versus Grant McCroll, case number CRA 23499, AZ&Z, CRA 23498. Tracy Hill is on deck.
Sir, are you Grant Pearl? I'm Judge Capper at the Lawrence County Municipal Court. This is your arraignment hearing. Everything you say today, sir, is being recorded. You are appearing in the court on a television monitor, and your image and audio is all being recorded. You're not required to say anything. You can remain silent if you wish. But if you do make statements, what you say can be used against you. If you admit something damaging to your case, you have a right to have an attorney, to have one appointed if you can't afford one, to have bail, to make the state prove charges filed against you beyond a reasonable doubt. Do you understand all those things?
Yes.
Okay. First case, 23499, A, B, and C. And these were faxed down to the jail this morning. So you should have them. 499A alleges that on August the 15th in Union Township, knowing there was an official proceeding or investigation in progress or about to be instituted, did alter or conceal something that was could be used as evidence in those proceedings. So the charge against you is tampering with evidence. It's a felony of the 3rd degree. Maximum penalty is 5 years in jail and an $8,000 fine. 499B alleges receiving stolen property. That on August the 15th you did receive or retain property being a Kia automobile that was the property of another person and had been obtained through a theft offense, that you had reason to know that it had been obtained by a theft offense. So the charge is receiving stolen property. It's a felony of the 4th degree. Maximum penalty is 18 months in jail, $5,000 fine. 499C alleges that August 15th in Union Township, you knowingly were in possession of a controlled substance involving fentanyl-related compound. That is possession of a fentanyl-related compound. It's a felony 5, maximum penalty a year in jail, $2,500 fine. And then the last charge is 23498, and actually that's out of state charge from Cabell County, West Virginia. It's alleged that there is a complaint filed against you over there and a warrant for your arrest on grand larceny and willful injury or destruction of property. Those appear to be felonies in that state. So you have a right to an extradition hearing. That's a hearing to determine if you are the person being sought, the grant accrual being sought by Cabell County authorities, and if the court should order you to go to that jurisdiction. You have a right to have an attorney on that as well. Do you understand the charges that have been filed against you, Mr. Pruitt? Yes. Do you have the money to hire a lawyer? Do you have money with which to hire a lawyer?
I do not.
Do you have a job?
I work for myself.
What do you do?
I'm trying to get this business off the ground. I clean, make apartments, renovate.
It's a cleaning business, is that what you're telling me?
Yeah, I clean apartments.
Okay, what do you, have you been working?
I have been, but it's just now getting off the ground, really.
When did you start working?
Within the last month.
How much do you make in an average week?
It depends. We've had some interruptions to our work, and it's where we don't make nearly, we haven't made anything in the last 4 weeks.
You had no income coming in the last 4 weeks?
No.
I'll appoint Mr. Steyer. Is there other attorneys here? No?
I'm sorry?
I'm going to get you a lawyer. All right, Mr. Steyer, is there other, no? Mr. Steyer, this is Grant Cruel. It's on, these are all felony charges. Receiving stolen property, fentanyl-related compound in his possession, and he has a felony warrant from Cabell County.
Okay.
So what's the state's position on bond for Mr. Cruel?
Your Honor, it appears that the warrant from West Virginia is directly related to this charge in that it's the vehicle that is alleged to have been stolen from West Virginia that he was in possession of in Ohio. The reason I know that is because at the time of the arrest of Mr. Cruel here in Lawrence County, an officer from West Virginia came over and connected the dots. This is the guy that we have stealing the vehicle in West Virginia. So we would ask for a bond on that, give him a time limit for West Virginia to come and pick him up. It's probably the best thing for us to do to nolly these felony charges to the grand jury.
Okay.
Well, if you're nollying those now, that, just to be clear, you're going to go ahead and nolly them now? Because they won't start, well, right, but they won't start the time on him until those are nollied, is bringing that up.
Right.
Okay.
As long as there's a bond on him on the other, on the extradition.
Then do you want a cash or surety bond or just a bond?
Cash or surety bond.
Okay.
$10,000 is our
It's
request.
grand larceny and willful destruction of property is the charges in Cabell County.
Okay. For the moment then, Your Honor, I think the best thing to do would be to set this for an extra, if he's gonna make that motion and the court's gonna put a bond on him on the extradition matter, then let's set this for an extradition hearing, and I'll talk to him about, well, let me just ask the question. Do you think you can make a bond of $10,000? You'd have to pay about $1,000 to a bondsman. Do you think that's something you could make?
Yeah, I can find, I gotta ask around, probably get that. And then what would I do then, sign extradition?
Well, you have to waive your right to extradition, and then the judge would give you a certain amount of time to get to Cabell County and turn yourself in, and set you back here. I'm gonna just say he usually gives about a week for that. I don't know if he can give a week, 2 weeks, what he would give due to the docket situation. But whatever date he gives you here, you have to have gone to West Virginia, and if they leave you out of jail, you come back here and you show that you appeared. And if you're in jail and you don't show up, what we'll do, if you don't show up, what we'll do is I'll pull up the Western Regional and see if you're in the jail there. And if you're in the jail, then we'll say, hey, look, they've got him. And if you're not in the jail, then the judge will probably issue another warrant for you here too.
Okay, so let me understand this.
Here, okay, let me just stop this. I'm gonna let you talk to him.
Okay. I'll call him.
60 people in on your conversation with him.
Can you ask that they keep him out, and I'll step out and call him immediately?
Yeah, I'm gonna set, just so you'll know what you're dealing with, on the matter to West Virginia, I'll set bond at $10,000 cash or surety, and then we'll come back and talk about dates and so forth as to when the next hearing will be set. And the state is making a motion to nolly the charges here to the grand jury, directly to the grand jury.
Yes, Your Honor.
Okay. This case will be recalled. You can have the court's files when you're ready. Just let the bailiff know. So we'll have you back, Mr. Crowe, after you've talked to your lawyer. He'll call by telephone and talk to you.
State of Ohio versus Tracy Hill, case number CRB 21643. Kenneth Roberts is on deck. Mr. Morgan's case.
This was from the court yesterday.
Is Mr. Morford here?
Yes.
We need Mr. Morford in the courtroom, please.
Judge, I had him yesterday at Ironton Municipal, which is, I can bring you up to speed where we're at. Because he was released to treatment, I have a treatment provider here, but he couldn't get out of jail because of the case here.
There's a hold on this case. That's where you can get a treatment. The hold? Yeah, the hold here.
Okay, this case, 21643, which I'm sure you don't have your file, he was arraigned back in September of 21, had a pretrial September 24th of 21, did not show up. Bench warrant was issued, and just now got arrested and is being arraigned on the failure to appear. And he was in Ironton Municipal yesterday and pled guilty to an offense and got a suspended sentence with a order for residential treatment.
He got a 10-day jail sentence. It was 180 days with 170 suspended and credit for the 10 days he'd already served. So he's got 6 cases from here from 2021, and they're similar in that they're violation of protection order charges and things of that nature. There's also a resisting arrest, a theft, criminal trespass, and the CRA 21 CRA 529.
Well, there must be some other, I don't have all those files.
Well, anyway, okay, so what we have here.
Tracy R. Hill.
What do we have? One violation of protection order charge here?
Yeah, well, that's still pending. That was never completed.
Right, so our agreement was to recommend if he pled guilty to this charge here, that it would run concurrent with what he got in Ironton Municipal Court.
One, in case we have to look at 21, and then there's multiple charges in 18.
Yeah, let's see, let's have, and I'm sure have you talked with him, Mr. Morford?
Not since Wednesday, Judge.
Okay, so you've talked to him since he got arrested?
Yes.
He apparently has some other cases here that are not completed.
Judge, I don't have a file on me. The only case that I have is 21643.
Yes, that's still pending. But I would say there's other cases that he was ordered to do things that he didn't complete, so that's what I want to see.
Okay.
I want those files pulled, and we'll deal with it then. So we'll have Mr. Hill back after I get all his other uncompleted files out.
Thank you, Judge.
So we'll come back to you, Mr. Hill, later.
State of Ohio versus Kenneth Roberts, case number CRB 23142, and Brian Shackelford is on deck.
Your Honor, we're set for a violation of protection order. We'll plead guilty to that today and ask that he be given suspended time and credit for his time served so far.
All right, Mr. Roberts, did you hear what your attorney represented to the court?
Yes, sir.
Do you agree with it?
Yes, sir, I do.
And the state's in agreement with that?
Well, what the state is going to recommend is 60 days in jail, credit for time served, suspend the rest of it, and as part of his probation, actually what we'd like to do is have him plead and take care of the treatment, and we believe he needs AOD assessment and treatment and also anger management. So we would want to see something done about that before we would agree on the sentence. But if he's successful in that, we would agree with him not going back to jail, but having a suspended jail sentence.
We'll be okay with an assessment. If the court wants to set it for a sentencing date, we can get that done before the next sentencing date.
All right, Mr. Roberts, you still living in Ironton?
Hey, Colorado.
Okay. I had 161 Township Road, 181 Ironton. Is that where you live now?
Yes, sir. Yes.
How do you pay for medical services?
I have a card, state.
You got an Ohio Medicaid card?
Yes, sir.
Have you been to treatment before?
Yes, sir.
Where did you go before?
Canton, Ohio.
Inpatient or outpatient?
Inpatient.
What's your drug of choice?
It was cocaine.
All right. Can you do a telephone assessment? Okay, I'm going to have someone call down, do an assessment. I'll have you back after they've talked with you. We're going to decide how we're going to proceed. If you're going inpatient, outpatient, where you're going to be, that sort of thing. So I'll have you back on the television monitor after you've done your assessment by phone.
Thank you.
Okay.
Well,
State of Ohio versus Brian Shackelford, case number CRA 23497, TRC 1771, CRA 18632. Cody Smith is on deck.
sir, are you Brian Shackelford?
Yes, sir.
I'm Judge Capper. This is your arraignment. You've got a charge out of state, and you've got an old case that you didn't complete at Celeste, so I'm going to go over those things with you. First, to remind you of your rights. You have a right to remain silent. You don't have to make statements, but if you do, it's all on the record. It can be used against you if you admit something. You have a right to have an attorney, to have one appointed if you can't afford one, to have bail, to make the state prove any charge beyond a reasonable doubt. Do you understand those things?
Yes, sir.
It's alleged that you have a warrant for your arrest in Wayne County, West Virginia. For some sort of manufacturing and possession of narcotics. And they're asking for you to be extradited from this jurisdiction to that jurisdiction to face those charges. You have a right to have an attorney, to have one appointed if you can't afford one, on the whole issue of extradition. It will not be an issue for me to decide whether you did or didn't do what they allege. It's for me to decide if they have enough reason to have you brought to their jurisdiction to face these charges. Do you wish to have an extradition hearing? Do you want a lawyer appointed? You can waive extradition, and that means you are agreeing to go to Wayne County to face these charges.
I'll waive.
Okay, we'll send down a waiver for you to sign. I'm going to set bond on this at a pretty serious charge. Well, let's deal with this too. We'll come back to that and I'll talk about bond. It's also alleged that you had an OVI conviction in this court back in 2018, and you had a review hearing December 23rd of 2022 on that OVI. It's alleged you didn't show up for that hearing, got a warrant issued. I'm showing that you did some of your community service, but you didn't finish it, and you still owe fines. Do you admit or deny you failed to appear for your review hearing back in 22?
Yes.
Yes, you admit, or yes, you deny?
I admit.
Do you have any explanation for not doing it?
No, there's no explanation.
Okay. I'll find you in contempt then on not coming to court when you're ordered to. So what I'm going to do, these charges in Wayne appear to be pretty serious. So I'm going to set bond at $25,000 cash or surety. Is that a bond you think you could post?
No.
And I'm going to send down a waiver of extradition for you to sign. And I'm going to give them a week to pick you up.
Okay.
So I'm going to put him back on my docket for next Friday, which is the 25th. So you should be in Wayne County by then, but if you're not, that means something didn't happen that should have. I just don't want you sitting in the back of the jail and nobody know you're there. So I'll put you on the docket. We'll check to make sure you're already gone. You should be to Wayne County by next Friday.
Thank you.
And so jailers listening in, go ahead and notify Wayne County he's available immediately to be picked up. And then what I'm going to do on your OVI that you had here, I'll set it out for a couple of months. So if you're out and about and free to come, you got to be here October 20th for a review hearing. If you can't come, you're in jail, then you need to come as soon as you get out of jail. We'll take care of that OVI that you had in this court. Do you have any questions, sir?
No. Thank you very much.
You're welcome. So put him on my docket for August 25th at 10 o'clock for a pretrial, just to check to make sure he has gone to Wayne County, and the clerk needs to fax to the jail the waiver of extradition. I'm putting a note on the file for that.
State of Ohio versus Cody Smith, case number CRB 23210, TRC 222099 A and B, and TRC 231057, CRA 23477. Mr. Stratus and Mr. Holt. Two attorneys are Mr. Holt is not here yet.
Okay.
Your Honor, I think we can resolve the felonies that Mr. Holt is assigned to. I believe the state's just going to go ahead and nolly those.
Okay.
And then we'll, I guess, discuss the other.
Nolly to the grand jury or nolly?
Well, his lawyer on the felony charges is Mr. Holt.
Yeah, and he texted me that he couldn't be here today.
Oh, Lord. All right, well,
and I told him that is a waiver of time constraints by default. Never got a response.
okay. I'm not prepared to nolly the charges to the grand jury. I think I had a reason to do that because he was being held on something else, but I can't confirm that right this minute. We may need to have a preliminary hearing. We have our victim here. We have other people subpoenaed. So
we can go ahead. I mean, he's got a lawyer, Mr. Stratton. Mr. Stratton just doesn't appear in the common police court, as I understand. He can appear here.
Your Honor, I believe he does have a probation holder. The officer is here, and I believe the officer will attest to that.
Maybe it's my note here. I said. And it may be that he has a community controlled sanction holder already.
But you want to check on that then?
We could do that, or we could have the hearing, or...
Why don't you check on it, and we can have the hearing if we need to later.
Okay.
This case will be recalled later in the session.
Recall.
State of Ohio versus Flint E. Topping, case number CRA 23482. Tracy Hill is on deck.
Flint Topping. Sir, are you Flint Topping?
Yes.
All right, Mr. Topping, I'm Judge Capper at the Lawrence County Municipal Court in Chesapeake, which is where your case is filed. And you are appearing in the court today by teleconference. Everything you say is going on the record. It's being recorded. You have a right to have an attorney, to have one appointed if you can't afford one, to have bail, to make the state prove this charge beyond a reasonable doubt. Do you understand those rights?
Yes.
The charge against you is felonious assault. And this was faxed to the jail this morning at 9:05 a.m., so you should have the writing, or it should be there for you to get, the writing, the written document. It alleges that on August the 3rd of 2023, in Perry Township, you knowingly caused or tried to cause serious physical harm to Whitney Burgess. That's a felony 2. The maximum penalty is 8 years in jail and a $15,000 fine. Do you understand the charge?
Yes.
Do you have the money to hire a lawyer?
No, I don't.
Do you have a job?
I did have.
Where did you work?
I worked part-time for my family, Topping Services.
What's Topping Services? Were you paid a salary or by the hour?
By the hour.
How much?
$10 an hour.
Okay, well, you're qualified for court-appointed counsel then. Mr. Smith, I'll appoint you. What's the state's position on bond? And I have a Kits Hill address for you, Mr. Topping, is that correct?
Yes.
Your Honor, it's alleged that he put a woman in the hospital with injuries. He's been convicted of felonious assault before. So we're going to ask for a $100,000 cash assurance.
Okay. I'll set bond at this point at $100,000 cash or surety. I'll let you talk with him, Mr. Smith, if you want me to revisit bond.
I will, Judge, but I'm going to assume that he can't make that if we could set this for next Friday to get within the time frame.
Okay.
I'm available next Friday.
That is the 25th.
Okay. But I will still talk to him, but I'm going to anticipate he can't make a bond anywhere near that.
August 25th will be the preliminary hearing at 10 o'clock. Bond is $100,000 cash or surety with an order. I'm assuming you want a protection order also.
That's correct, Your Honor, and we'll prepare one for...
Okay, if you do make bond and get out, you have to stay away from the complaining party, which is Whitney Burgess. You're not to go around her or contact her. Next hearing is August 25th, 10 a.m.
Thank you, Judge.
You're welcome.
I have a question, Judge Pepper.
Yes, sir.
The attorney is Smith?
Yeah.
He's right here. You can see him on the
I'm
screen.
going to call you so we can get you off the screen. I'm going to talk to you on the phone. I'll call up to the jail.
Okay, it's all here on it. I'm sorry.
Okay, yeah, I just don't want you talking in the courtroom. I'm going to call you up there at the jail and talk to you. All right, Flint.
State of Ohio recall Tracy Hill, case number CRB 21-643 at Lawrence County Jail.
Okay. All right, this is the only open case.
Please have changes, please, Judge.
All right, we took a recess to check and make sure there was no other old open files or files that are uncompleted. Told by the clerk that there aren't. So this is it. And now it's my understanding, Mr. Morford, you want to enter a plea on this matter? Or?
Yes, Your Honor. When you had the case recalled, I called him and made sure that he was still on board with this. And he is willing to change his plea to guilty to the count one count.
The charge is violating a protection order?
Yes, Your Honor.
You agree with that, Mr. Hill?
Yes, sir.
All right, I'll accept your guilty plea. Do you have any statement you want to make to the court before you're sentenced?
Not really. Like I said, at the time whenever all that happened, I was in bad shape, and I'm just trying to change my life now and try to make it better.
What's the state's position on this sentencing?
Your Honor, the state's going to ask the court to issue the same order that we received in Ironton Municipal Court yesterday, which is 60 days in jail with credit for 10 served, 50 days suspended, and the treatment program that's already been approved for him that's in Ironton Municipal Court.
New Life Recovery?
Yes, sir.
This will be inpatient?
Yes, sir.
All right. Mr. Morford, any response to what the state's saying?
No, Your Honor, we would ask you to adopt that as a joint recommended sentence.
All right, I'll do that. I'll impose a $200 fine. Order the cost be paid. 60 days in jail, 50 suspended, credit for 10 days served. He's ordered to complete inpatient treatment at New Life Recovery. Serve 2 years of level 4 probation. I'll set a review hearing for October 20th at 9 a.m. And if he violates any terms of your treatment, I'd like to know it before that date, and we can either bring him in or issue a warrant for him if he leaves.
Yes, sir.
Okay, you're going to pick it up today, or?
Yes, sir.
Okay, you'll get released to the treatment facility today, Mr. Hill. You have to do what they set out for you to do, unless it's illegal or immoral. You have to do it as they tell you to do it. Well, I have a lot of problems with it. People go to treatment and they think they're in charge of their own treatment. You are not in charge. You are to do what you're told, when you're told to do it, how you're told to do it. And if you don't like that, you can come back and talk to me about it. No insurrections. Mr. Hill.
Well, Your Honor, we just want to remind him that this civil protection order that was issued from the Lawrence County Court of Common Pleas is still in effect. And so we want no more anything close to a violation of that, because the next time would be a felony.
So you're on the abyss, looking over into a black hole that you can cast yourself into by your behavior. So if I were you, I'd be on my best behavior and get good reports. Because you'll come back and I'm going to get a report on how you're doing. So, let's make some changes.
All right, thank you.
You're getting an opportunity here. Take advantage of it, make some changes, become a new man.
All right, thank you.
See you on October 20th.
Thank you, Your Honor.
State of law recalls Grant Cruel with the Lawrence County Jail, case number CRA 23498, CRA 23499, A, B, and C. Kenneth Roberts is on deck.
Okay, this is Mr. Steyer's case, and you had a chance to talk with him?
I did, Your Honor. Mr. Cruel believes, well, I'm going to get the headphones on, sorry. Can you hear us, sir?
Yes, ma'am.
Okay. Mr. Cruel believes he can make bond. I've gotten in touch with his wife, given her Mr. Sowers' phone number. So steps are in place to get that done. So we believe he'll be making bond. Just a little bit of clarification. I don't think that there may be some misunderstanding of the jail that the bond that's being set and that would be posted here is a bond on the holder. And so it would result in his release from the jail on the holder without a release from Barbersville, because you have the power to set a bond on that.
Yes. So what's happening is the state's going to nollie the Ohio charges to the grand jury, so he can get indicted on those, but there's no holder on those. That's going to be presented to the grand jury down the road. Probably, I anticipate, would be an indictment issued at some point in the future on those Ohio charges. In the meantime, he's going to go back to West Virginia to face the charges there on a bond of $10,000 cash or surety, and he can post that today.
He believes he can get posted today. I've spoken to his wife. She believes she has the money
He'll sign a waiver
available.
of extradition.
Do you want him to sign the waiver today then at this point? That's fine. So the waiver will be sent down, sir. You'll sign that, and the bond will be posted, and then the judge is going to give us a date to have you back. And as I explained, you have to come back that day and prove that you have presented yourself to Cabell County.
That's Wayne, I believe.
Is it Wayne County? I thought it was Cabell. I'm sorry.
You're right. There was another case that was.
Okay.
This is Cabell County.
Okay.
Cabell County.
So you have to come back here on the date the judge gives us with proof that you have presented yourself to Cabell County.
Yes, sir, I understand.
So I'm going to make it before next week, August 25th at 10 a.m. So you either have, here's your choices. You get to Cabell County, turn yourself in so that they withdraw the warrant. If they withdraw the warrant, all's good, then the case here's fine. If they haven't withdrawn the warrant, you got to be here in this court and explain why you haven't got the warrant withdrawn, or the bail bondsman is going to be turned on the loose to go find you, and he's not going to want to pay $10,000 to the court, so he will go just about anywhere for $10,000.
And just so you know where we are here today, sir, we are at the Chesapeake Municipal Court. It's across the street from the flea market.
Okay.
And are we coming back here on the 25th then?
We are.
And I need to sign waiver of extradition?
And that'll be faxed to the jail.
Okay. I'm still confused as to how, with Cabell County has a hold on me, how posting the bond here
Because
would allow me to walk free.
Because this is a bond on the holder. I explained it to you on the phone. I promise you, this is a bond on the holder. That's what the bond is for.
So let me make sure you understand. Mr. Kroll, once you post the bond, I'm ordering you to turn yourself in. You got a week to do it in Cabell County, so just listen.
Understood.
I don't care how you do it, if you go over and turn yourself into the jail or walk into the courtroom, whatever you do, you got to get before Cabell County authorities in the next week, where they take custody of you and withdraw the warrant. If they want to let you go, that's fine. I have no control over that. If they put you in jail, so be it. But you have to get that done. And if you don't do it, you got to come back here next Friday at 10 a.m. There'll be a hearing. If you haven't done it, you've got to appear here and explain why. And you're subject to be going back into jail then if you haven't appeared in Cabell County. And if you don't appear, if you're going to blow off the whole thing and say, I'm just going to jump bond, I'm not going to comply with bond, then I'm going to release the bail bondsman. And he's like a hound. I call it releasing the hounds. He and his sons will be out scouring the earth for you. And they will throw you in a car and take you to the jail.
I have no intention of doing, is that the right thing here, sir?
Well, you know what? People do it. I just want you to understand what the lay of the land, what's going to happen if you make certain choices, because that has happened before. People have jumped on, not come to court, say, I don't think that guy can find me, I'll go hide out. He's pretty good at finding people. So what I always tell people, if you want to leave, you better go to some country that does not have an extradition treaty with the United States. That's probably not a place you want to live, but that's where you have to go if you want to, because this warrant's going to be good throughout the United States and any country that has an extradition treaty with the United States, which is most countries. Probably Iran doesn't have an extradition treaty.
Yes, sir.
I don't know. I'm not giving you advice to go to Iran, but I'm just telling you what's going to happen if you don't come to court.
Okay, understood.
Okay, so the clerk will need to fax this down to the jail for him to sign.
Thank you.
And put it on the docket for August 25th. 10 o'clock.
State of Ohio recalls Kenneth Roberts, Lawrence County Jail, case number CRB 23142. Cody Smith is on deputy.
Okay, this is one where Bethesda was doing an assessment of Mr. Roberts by telephone at the jail. We were going to figure out what kind of treatment he would get and bond and...
He denies any type of substance abuse issues within the last 3 years, but states that he has mental health issues. So we can do outpatient, we can try that at first and see, and we can also combine the anger management in there with him and do some substance abuse, very minimum on the side.
Mr. Hill.
Well, we trust the assessment, and it may be when they get into it, they'll discover some things that will lead to further different kinds of treatment. The main thing that we want to do is make sure that there's no contact between Mr. Roberts and Miss Diane Roberts, the victim in this. And there is a protection order from Lawrence County Common Police Court that's in effect. So that will protect her from, if he knows what's good for him. And we'll come back, we'd ask to come back at a later date for sentencing.
Your Honor, I thought we addressed that protection order last time with the felonies.
Could we possibly have him screen there just to verify?
How long? He's been in there a while, though.
Oh, okay, well.
I think. He was arraigned on the warrant on August 7th, so it's been 11 days.
Yeah, won't do any good.
Your Honor, I guess there is a protection order in place, so.
Okay. So do you want me to complete sentencing or hold up the sentencing until we see how he does with his treatment?
We'd like to see how he does.
Okay. So what I'm going to do, I'm accepting your guilty plea today. I'm going to delay sentencing, and I'll do the sentencing after you go to treatment. So you have to comply with the treatment, and you're going to do outpatient. You know where to go to, Mr. Roberts, for your outpatient treatment services?
No.
Yes, sir.
He needs to, and we need to see him Monday at like 9 o'clock. He can go either to I can call him back and let him know exactly where to go.
Okay, so they're going to call you and give you direction on where you have to go. So you understand you have to do this, and I'm going to sentence you at a later date. So part of your sentence will depend upon how compliant you are. The better you do, the more lenient I can be on your sentence.
Yes, sir.
And I want to remind you, there is still a protection order in place that you're to stay away from, is it Dreama? Diana Roberts. You're not to go around her. Do you understand that? Or contact her?
Yes, sir.
And you will do that?
Yes, sir.
You'll be compliant. Well, let's come back for sentence. Yes. Do you have a question, sir? Mr. Mr. Roberts, you have any questions?
I don't believe so, Your
No,
Honor.
sir. Okay. Let's come back on September, can you be here the 5th? That's a Tuesday.
Yes, yeah, I could be there.
First sentencing, and I don't know that I'll complete sentencing then, but I want to report on how you're doing September the 5th. So that's what's going to happen. We'll come back. They're going to give me a report as to whether you're doing what you're supposed to. And if you are, I'll probably give you some more time out without concluding it, but I just want to check to make sure how things are going. September the 5th, that's the day after Labor Day. You got to be here at the court at 10 o'clock. In Chesapeake, court in Chesapeake.
Thank you, Your Honor.
All right.
You have to let him know.
State of Ohio recalls Cody Smith, case number CRA 23477, CRB 23478, CRB 23210, CRC 22299.
I trust him, but I still want to make sure that all the...
So we were checking to see if there was a holder on him.
There is a holder on him, and Your Honor, I just out of an abundance of caution, I've sent a message to Chief Bowen, the Community Control Officer, the head of that department, and I want to make sure that there's not going to be a situation where there's a cross-up and he gets out of jail.
Your Honor, we have a domestic and a felony together. We also have a separate domestic, which is set for a pretrial.
There's an OBI too.
The
TRC 231057.
The
Is that already
OBI
resolved?
The OBI is linked to the felony. There is a domestic violence from earlier the same day, and I don't know the nexus there that, yeah. He also, Your Honor, when he left court here, I guess they brought him up here one day recently, I forget, but, or something happened. Anyway, he made contact with this young lady, I guess, on the street when they were taking him out of the van.
Yes, he was they were transporting him back to the jail, and I was in front of the courthouse.
So they've got another charge in Ironton Municipal Court on him. So he's got plenty of charges.
Do you want to wait to hear back from Chief
If I may,
Bowen?
please.
Okay, we'll recall this after the prosecutors talk to the adult probation. Okay, he's the only thing we've got left at the jail, so he'll be the first person and only person we call back. I should have had him sign. Let's send it over, have him sign $1,000 work on. Yeah, make it whatever I had as cash tree, make it over. Because it's percent. Okay, that's fine.
State of Ohio recalls Donald Dickus, case number CRA 23104, CRB 23105.
Where is Taylor?
She just went outside to smoke.
I want her in the courtroom on this.
That's mine.
Would you approach the bench? Have you seen their screen?
Okay, we've got this.
If Have you seen the screen, Mr. Dickus?
Yes, I was there.
Well, here's your choices. Either jail or go to inpatient.
Yes, sir. And it's 30 days in jail? Do 30 days. Can I have time
Commanded into the hands of the sheriff.
Can I have time to get my,
No, you're going right now.
Thank you, Your Honor.
I need the probation officer in the courtroom.
Sir, sir.
Yeah. Come up here to the jury box. Have a seat. I placed Mr. Dickus in jail. He's going to jail for 30 days.
Okay.
He tested for cocaine and alcohol.
Okay.
He prefers 30 days to inpatient. And I'll set his next hearing for September the 15th. To be a review.
State will file recall Cody Smith, Lawrence County Jail.
That was quick.
Nominate the ones to the grand jury that we need to. So, are we ready to?
We don't have, is the jail where we need Cody Smith?
There he is.
Okay, he's back. You got some information?
We can confirm now that there is a community control holder on him that will stay in place regardless of what we do here. So we'll nolly the felonious assault and the OVI that happened at the same time. And also the domestic violence, we'll nolly that too, that 23 CRB 478.
Okay, so case numbers 23-477, 478, and the TRC case number 23-1057, which is the ODI, are all nollied to the grand jury.
Yes. And then I'll ask that we just reset the other domestic violence for a pretrial.
And that is case number 23-210.
Yes, I
And
believe.
then he had a prior ODI that had been set for a review hearing. That's 22-2099. So we schedule all those for another hearing.
Yes, Your Honor.
When would you like to do that?
Let's do that maybe the middle of September sometime.
September 15th?
Yes.
All right, 23-210, September 15th, as is 22-2099. The other cases are leaving here and going to the grand jury.
Okay, thank you, Your Honor.
You understand that?
Yeah, for most reviews or.
Pre-trials.
I think I'm done.
Hey, Sean.
Okay.
Okay, that finishes up at the jail. So we'll come back here for pre-trials and other cases here at this court. The next thing we're going to be doing are arraignments. We have some arraignments here that the paperwork's just been finished, so we'll do those next, and then we'll start with the pre-trials.
State of Ohio versus Alexis Kane, case number CRB 23502.
Alexis Kane.
State of Ohio versus Bobby Rose, case number CRB 23501. Bobby Rose.
You're Alexis Kane? Bobby Rose? You come up to the table also.
State of Ohio versus Aaron Hale, case number CRB 23500.
We've got papers coming to each of you. So Alexis Kane is to the far left, Bobby Rose is in the middle, correct? And then to the right is Aaron Hale. Record reflect, they're each being served with a copy of the charges. Alexis Kane, the allegation is that on August 17, 2023, Fayette Township, you purposely deprived Walmart of property without their consent. It's a first-degree misdemeanor theft offense. The maximum penalty for that is 6 months in jail and a $1,000 fine. Do you understand the charge, ma'am?
Yes, sir.
Do you understand your rights?
Yes, sir.
How do you plead to this charge?
Guilty.
Bobby Rose, same charge, same date, August 14th, Fayette Township, that you tried to deprive Walmart of property without their consent. It's a theft offense. 6 months in jail, $1,000 fine, is the maximum penalty. You understand the charge?
Yeah.
You understand your rights?
Yeah.
How do you plead?
Guilty.
And then Aaron Hale, same charge, theft offense, Walmart, August 14th, maximum penalty, 6 months in jail, $1,000 fine. Do you understand the charge?
Can you go over one, like, I don't understand. This is my
Okay.
first time ever.
The charge is theft.
Mm-hmm.
It's alleged that you committed a theft offense.
Yeah, I meant like the guilty, not guilty.
Oh, okay.
Sorry.
You have three choices as to a plea: guilty, not guilty, or no contest. Guilty and no contest usually result in the same finding. No contest just means you don't want to put up a defense and you're agreeing you can be found guilty without a trial and a lawyer. Guilty means you're admitting the charge is true. Not guilty means you're denying it. If you don't know what to do, I would recommend you enter a not guilty plea. So, how do you want to proceed?
I'm confused, I'm sorry. If I say if I was guilty, does that mean I'm going to go to jail?
I don't know. I haven't heard I have to hear what the state is alleging, what the state wants, and that sort of thing. So I don't prejudge the case until after I have a plea. Then I'll decide based on the evidence what the sentence should be, not beforehand.
I know, I'm sorry.
Mr. Neal.
Your Honor, none of these are accompanied by a trespass charge, which tells me that Walmart's never dealt with them before. We don't have any indication or request for restitution. So our recommendation would be a suspended jail sentence and some community service, small fine, order to stay out. Well, I don't know if you make an order for them to stay out at Walmart, but and some community service and probation.
Okay, so that's the prosecuting attorney. His job is to bring the charges. My job is the judge. So he can make a recommendation, which I can follow, but I don't have to follow. So you know what they're recommending, but you don't. Still, there's no promise as to what there is no promise as to what the sentence will be. So how do you want to plead?
I'm guilty. Guilty, sorry.
Okay, so all three of you are entering a guilty plea. So my standard procedure now, because I get so many positive screens, is I'm going to order all of you to do a urine screen. So go do a urine screen, and I'll send you after I see the results of your urine screens.
State of Ohio versus Jade Lewis, case number CRA 23432 A and B, CRB 23433 A and B, Jade Lewis.
And I have, this is Mr. Morford's case. It's not on the docket today. Ms. Lewis showed up today. She was supposed to be here, according to my record, on July 24th for a preliminary hearing and pretrial. Did not appear. So I'm assuming you have not talked to your attorney today?
No, I called up here and they said that he was supposed to be here.
Okay. He is here. You're standing next to him.
Oh.
So go talk to him. You can have the court's file when you're ready. Come back and we'll go from there.
Okay.
You're welcome.
State of Ohio versus Braylon Colburn, case number CRB 23503.
Ma'am, you're Breland Colburn?
Yes, sir.
Ms. Colburn, it's alleged that on August the 15th of this year, in Fayette Township, you purposely defrauded Walmart of property without their consent. It's a first-degree misdemeanor. Maximum penalty is 6 months in jail and a $1,000 fine. You understand this charge?
Yes, sir.
You understand your rights?
Yes, sir.
How do you wish to plead?
Guilty.
Guilty means you're admitting it's true. Is that what
Yes,
you
sir.
wish to do? Okay, go do a urine screen, come back. I'll send you after I get the results. Okay, we're going to start pre-trials next.
State of Ohio versus Corey A. Cordell, case number TRC 23906 A, B, and C.
This is Mr. Smith's case, and it's set as a pre-trial today.
Correct, Judge. This is a fairly recent case. It's a urine case. We would ask it to come back in a couple weeks.
We've checked on that this morning to see if they were available and the results are not.
We're about
Not
7
yet
weeks
available.
out.
Yeah. So we don't have.
When's our, do we have a time issue?
Well, the time runs about October 1st, or thereabouts, so we have some time left.
Hey, Judge, can we come back in on September 1st? Hopefully that'll be a month before the time runs.
All right.
I need to talk to my client.
All right, next hearing will be September 1 for pre-trial, 10 o'clock.
State of Ohio versus Justice Hutchinson, case number CRB 23453.
September 1st. There's a co-defendant on that one, Ron.
Candace Paul, Your
Thank
Honor.
you.
That's your case?
Yes.
It is.
Okay, call Candace Paul is Mr. Steyer's case. Justice Hutchinson is 23-453. It's Mr. Smith's case, pre-trial.
We want to make sure it's a
State
Friday.
of Ohio versus Candace Paul, case number CRB 22454.
Judge, discovery has been filed. We do have a video. We don't have it yet. We would like another couple weeks to look at it with our clients, if that's okay. We'll waive time.
And Your Honor, we would ask for a Friday. She has, she's a student and she doesn't have classes on Fridays, so it'd be less disruptive to her schedule to come in here on Friday.
September 1st date. Is that a Friday?
I prefer the 15th.
For the
Is that good? Are you-
Sure, yes.
I'm not available the 15th. I'm available the 8th or the 22nd.
Okay, let me look at the calendar.
I could do the 22nd, not the 8th.
22nd's good.
It is, yes, sir.
All right, September 22nd will be the next hearing. Pre-trial, 10 o'clock.
22nd at 10.
And if you need the video,
Yes.
Have you received the video?
Yes, they're going to, I think, copy it for us before we leave today. Yes, we're going to have it today.
Okay, very good.
Thank you.
State of Ohio versus Shelby Rodriguez, case number CRB 23396, CRC 23816, A, B, and C.
All right, this is Mr. Smith's case, set for pretrial.
I'll give the DVD. It's a 3-hour DVD. These are my notes from I got them up and I'll give them to you. We're going to come back in 2 weeks. So that's what we're thinking. Yeah, we'll reschedule. Okay, we got the your testimony.
I'm so glad you say that. I was going to ask, I didn't know.
Are you okay? Oh, yeah. Judge, this is a urine test case. If we could come back in a couple of weeks. It's from June 30th or July 3rd. They should be here any day now, but as I understand, they're not available this morning.
Okay.
This is a July 3rd arrest.
So it's the same as that last one?
The same as the Corey, yes, sir.
All right, September 1st, and that's
Yes.
September 1 will be the
Appreciate it,
next
Judge. September 1 at 10 o'clock. Then I'll call it for you. You got it. Okay. Yeah. It's Rodriguez, Shelby Rodriguez.
Yes, sir.
I got it. I'll call you. Get together. Oh, okay. I want to talk to you. Yeah.
let's see, in September.
Yeah.
To the range. September 15th.
Domestic violence?
It's going to the grand jury.
That's never marked.
Well, there's 2 domestics.
All right.
There was one that happened at the same time the felony did, so they're taking it to the grand jury. The other is staying here. It didn't happen. Anything that happens at the same time as felony, they can take it to the grand jury.
State of Ohio versus Kyle Davidson, case number TRC 23764, A, B, and C. Kyle Davidson. Kyle Davidson.
Your Honor, we just need to set this for trial.
September 11th or 15th?
Your Honor, I'm not going to do the 15th.
Okay, 11th.
Your Honor, could we go about a week later on that? Maybe the end of September.
September 25th?
Yeah, that'll work.
September 25th for trial, and it'll be at noon. Do we need any pre-trials before then? That's more than a month from now.
No, we don't. We'll have it resolved. All right.
Noon for trial, September 25th.
All right, thank you.
Thank you, Rob.
Have a good day. All right.
State of Ohio versus LaVon K. Murray, or Laban K. Murray, case number CRB 23412, A, B, and C.
Okay, this was set for trial today, but I understand that there's been some arrangement that's going to be recommended to the court.
Yeah, I believe the state.
Well, we're not making the arrangements. Here's our, We haven't been able to serve the victim is what has happened. And I talked to Children's Services about it because Children's Services has been involved. And they tell me that they believe that our victim has moved to West Virginia and they haven't been able to locate her. They turned over the Children's Services aspect of the case to West Virginia. And we asked for a subpoena to be issued. Some of the witnesses were subpoenaed and received their subpoenas. And I don't know if they're here or not. But I guess what we would need to do is wait till noon. I guess the case was scheduled for noon, find out if our victim's going to show up or not. But we intend to have a trial or we've made an offer.
Your Honor, may we approach?
Why don't you just tell me from back there?
When you send them back with the state, and the state said they're going to dismiss the case, you come out there and call case early because that's what the state said they're going to do. That's what the state said back there they're going to do. Okay?
I said
And now
if
it's
we didn't
completely
have a
different.
witness, we would.
Okay, well, we'll wait till, it's not set till noon. We'll see if the witnesses show up. If they don't, they're not going to be able to go ahead with their case.
And Your Honor, if I may, I can call out here and see.
Well, were they subpoenaed to be here at noon, or, I don't want you to dismiss the case, and then somebody shows up at noon and says.
Right, well, that's right. Actually, our request for subpoena says 9 a.m. I don't know what it said on the actual subpoena, but we're looking for Claudia Crank, Michelle Murdoch, and Peyton, it's either Marbury or Mabry. So I don't
Any of
know
those
if
people here today?
So, with the trial scheduled for noon, so.
We can wait till
All right, case will be recalled.
State of Ohio versus Alexis Kane, State of Ohio versus Bobby Rose, State of Ohio versus Aaron Hale. Council recall.
Okay, let's do the easiest first. Aaron Hale. That's you, ma'am, all right? Yours was totally clean. So, anything you want to tell me before I sentence you? You have a right to make a statement. You don't have to make a statement. So I'm just giving you your right if you want to make a statement.
You can go ahead.
Okay. All right, I'll impose a $100 fine, order you to pay the court costs, 10 days in jail, suspended.
Okay.
But it's up, I'm putting the ball in your court. I'm giving you a suspended sentence, but you gotta do 5 days community service. That's pretty, as of today, that sounds pretty good. Further down the road, people are like, well, I don't really need to do that community service. You'll go to jail then.
I'll do it. Am I able to do it only on Saturdays?
Saturdays are good.
Okay.
It's a pretty good deal.
Awesome
You
deal.
get to sleep at your own bed, but you gotta come in and, you know, there's grass that needs cut, litter that needs picked up, other stuff you can do for the community, so it's not that hard.
Yeah.
But you gotta do it.
I'll do it.
I'm ordering you to stay, this is the hardest part right here,
Mhm.
about the toughest.
Okay.
No Walmart. You're not
That's
allowed to
fine.
go back to Walmart.
That's fine.
Okay, ordering you to stay out of Walmart. Yeah, and no Walmart. Yeah. 2 years of probation, level 4 probation. Your review hearing will be February the 16th of next year, so you'll get, you don't have to remember, it's gonna be on a piece of paper that you're gonna get before you leave.
Okay.
You have to do this stuff, that's plenty of time to get all this stuff done. And you can actually work, if you can't pay your fine, you can work it off. Do extra community service, you get $50 a day credit.
Okay.
If you haven't got it done, you gotta show up. This is the only way you can actually go to jail. And people do this, believe it or not. They don't do what they're ordered to do, and then they don't show up for their review hearing, and then they're surprised when they get nabbed on a warrant and go to jail. Don't be surprised if you don't do it, you go to jail.
No, I'm gonna do it.
Just do it, and you won't have, I don't want you to go to jail, believe me. You don't want to go to jail, it's way overcrowded, we don't need you in there. That's my only choice if you don't do what you're ordered to do. Okay, so that'll be at 9 a.m. on February the 16th. You're going to meet with the probation officer. He'll give you the judgment entry, which is all those things I just told you is going to be on that. And then if you get confused, we have phones here. We have a computer. You can pull up your case and see what you're supposed to do. There's no excuse for not doing what you're supposed to do. So the probation officer is to the left as you leave the courtroom, the open counter on the left as you go out in the lobby. Go over there, talk to him, get your paperwork, and then you can leave.
Okay.
Any questions?
No, thank you.
And you can put Walmart in. Okay, now, the next one. Bobby Rose.
Yep.
Case number 23501. Your screen shows buprenorphine.
Yeah.
Are you got a prescription for that?
I did, and I quit going, but I plan on going back because had a bad drinking problem, and I still got like 4 of them left from the last time. And yeah, I went 6-7 months without a job because I was in a car wreck, and then I just started my new job, and I'm waiting to get my insurance so I can go back and afford it. So yeah.
And you live in Canova?
Yeah. But like, I just got them sitting around because like, I don't know, I don't want to go back to drinking because I gave myself an ultimatum.
Well, I don't think buprenorphine's going to help you for that, but it may keep you out of the other stuff.
It helps, well, I was on other stuff too. But I just do it so I don't go back to drinking and my other stupid stuff like I used to do. And I did not too long ago. I got a little girl and I gave myself an ultimatum, the bottle for the baby. So, yeah.
Now, what's the relationship between you and these other two?
I don't know her, but Erin, she's my fiance and my little girl's mom.
And you have a child with her?
Yeah, she just had surgery yesterday. So,
The child or Aaron?
child.
Okay, where?
At 3 Gables.
Okay, outpatient.
Yeah.
Okay, well, you're not to take buprenorphine unless you have a prescription.
Yeah.
You're supposed to get a prescription for that.
Well, where could I get rid of them other ones I got? I got like 3 left, maybe. I could just throw them or take them to the police
So you had a
station.
prescription for those?
I did. I've had these forever. Like, they're probably expired. I could take them over at Canova Police Station if you want.
I'm sure they would take them.
That would work.
Okay, I'm going to give you the same sentences, her $100 fine, court costs, 2 years of level 4 probation, order to stay out of Walmart, review hearing on February 16th.
All right. 2 days before my birthday.
So go see Mr. Major in the probation office.
All right. I did.
You're welcome. Now, what's your relationship to those two? Okay, so this is 2 different incidents, okay. Not related. Well, yours is more of a problem. And you live in South Point, right?
Yes, sir.
How do you pay for medical services?
I do not have insurance right now.
Do you have a Medicaid card? You ever had one?
Yes.
Why don't you have one now?
I just didn't recertify.
But you're eligible for one?
What is it?
Are you eligible for a Medicaid card?
Yes.
Okay.
Could I,
Are you working now?
I am.
Where do you work?
I work at Outback Steakhouse in Ashland.
Okay. Well, did you see your screen, what you screened for?
I did, and I would like to ask for possibly some type of outpatient help. I recently, like in the last 3 days, lost a child and relapsed. And so I would like the help.
Have you been to treatment before?
I have not.
Never have?
No.
Well, you didn't test for fentanyl, but you tested for a lot of other stuff, and the problem in our community now is that if you get any drug off the street, you don't know really what's in it.
Right.
It could have fentanyl, and fentanyl is extremely dangerous. We just lost somebody yesterday who'd been in this court, under this court supervision on a drug overdose. Chester Fugate. So, for your benefit, you need to get off of whatever street drugs you're taking.
Yes, sir.
It's not safe. Do you have children?
I do.
How old are they?
I have a 6-year-old.
In school today?
Yes.
First grade? And you still living in South Point?
I am.
You have transportation?
I do.
You have a license?
Do not.
How do you get around?
My mother.
She here with you today?
No, she's not here.
Okay.
She had to go to work. She drops me off, and my grandma's going to pick me up when I'm finished.
Okay. All right. You got somebody who wants to talk to you, and I want you to talk with them and get something set up. And Cooper, would you let us see the screen? And then I'm going to come back after you've had an assessment, and we'll decide how we're going to proceed.
State of Ohio recalls Breland Holden, case number CRB 23503.
Okay. Anything you want to tell me, Ms. Colburn?
Just that I've learned my lesson, and it was a dumb decision that I shouldn't have made.
Yeah. Okay, based on your screen, I'm not going to order you to treatment, but I will give you a $100 fine, court costs, 10 days in jail suspended.
Thank you.
30 hours community service, 2 years of level 4 probation, order to stay out of Walmart. Review hearing on February the 16th
At 9 o'clock.
at 9 a.m. You're to go meet with the probation officer, Mr. Major. His office to the left as you leave the courtroom.
Thank you.
You're welcome.
State of Ohio recalls Jake Lewis, case number CRA 23432 A and B, CRA 23433 A and B. Jake Lewis.
This is Mr. Morford's case. It had been set for a preliminary hearing pretrial July 24th. It appears that Ms. Lewis was not here then, but she came in on her own today.
Judge, I put a letter from OVP in your file, showed her compliance with your orders to go there.
Well, why did she not appear in the hearing when she was supposed to?
She thought it was August 24th.
And what's the state's position on it?
Your Honor, I'm looking to see, I have an indication here that maybe she's got a case. Let's see here. That might be a felony, although I don't see it on here. An Ironton Municipal case that looked like it might be a felony. But here's the thing. We've got possession of cocaine, which is a felony, along with, okay, there's no OVI here, is there? We want to see her in treatment.
She's at OVP now. I have a letter from Rebecca McKinney at OVP saying she started services there on August 10th.
So if she's successful with that, we don't have a problem with leaving the case here. Hopefully, we won't have to take it to the grand jury.
I'd like to know, Brianna's here, isn't she, or she was?
She was here, you know.
Let's have her come. Here's my problem. It took her 2.5 weeks to start at ODP. And basically the letter that I have just says she started service. It doesn't say anything about what she's done. Ms. DeMint, this is Jade Lewis. She apparently started services at ODP on August the 10th. I'd like to know what she's done since then. And we get a report that updates us until today's date.
The one on 20th Street.
Yeah, just give me 1 minute.
Okay, we'll recall this case.
Thank you, Judge.
State of Ohio versus Elson and Childers, case number PRC 23629, A, B, and C. Mr. Stein.
This is set for a pretrial.
Your Honor, we're here today to see if the state has urine screening results.
This is one that at the time for the trial is running very close, and we do not yet have the urine results back. So this is the 18th, so
Actually, I think the trooper subpoenaed for today, or I have something, recipe for witness.
well, and that was inadvertent, and I've already talked to him. This is a pretrial today. But we will have to have a trial. Let's see, this is the 18th, so next Friday.
I'm here, Your Honor.
All right, this case will be set for trial August 25th at noon.
Go ahead and be your 10 though. Okay.
Thank you, Your Honor.
You are.
State of Ohio versus Cody Lucas, case number TRC 23708, A, B, and C. Cody Lucas.
Your Honor, I've looked for Mr. Lucas this morning and haven't seen him.
Okay, it's set for pretrial today. Does the state want a warrant, or?
Yes, Your Honor.
Okay, it's got 7 days before warrant will issue.
Thank you.
State of Ohio versus Cassidy Dorigo, or Derigo, case number CRB 23487.
Mr. Morford's case is set for pretrial.
How are you doing? Good, how are you? What do we got? Let's see. I know she's not showing already. Oh, I think you did. Does that affect anything if she doesn't show up? Huh? Does it change anything? No. They just pick that. Like if she doesn't show up, this table stays up. She doesn't have to be here.
Okay, today is the first pretrial. How do you wish to proceed?
Your Honor, we are lacking some information about the contact information from the alleged victim. So we would ask for a short continuance for us to run that information down and contact her.
September 1st? Is that enough?
Do I have her phone?
That's
Yes, Your Honor.
What day was it?
September 1st?
December 1st?
September 1st.
September, thank you.
Are you here then?
I believe so, yes.
September 1st. 10 o'clock for pretrial.
That's good.
State of Ohio versus Barbara R. Lawson, case number CRB 22709. Barbara Lawson.
Okay, I'll see. She don't have the phone. When you come back.
This is Mr. Morford's case. Barbara Lawson. She had been in the counseling center, but it's my understanding she was going to be transitioning from inpatient there to outpatient. Should be outpatient at this time.
I've got PAP as well, Judge.
Any indication where she is today?
No, can't help you there.
All right, she's got 7 days before warrant issues.
Thank you, Your Honor.
State of Ohio versus Hunter Tooley, case number CRB 23147.
Mr. Morford's case. He says hometown. I've got a report dated August 18th.
What is she? Where? What?
Okay. All right, this report I've been reading is for a different person. That's for Carl Tooley, and we're dealing with Hunter Tooley. I do have a report from Pat that was faxed to the court on August the 11th. Have you seen the report?
No, Your Honor.
Basically says he's not cooperative with treatment.
Honor, did Mr. Tooley enter a guilty plea?
I have that he did on April 7th. That's the note that I have. What is your note?
I had March 17th, but I guess we were here on April 7th. Nonetheless, I do have a note that says he pled guilty. Now, just in the spirit of complete disclosure, I have an indication, but it wasn't clear whether the court had allowed him to withdraw his plea later on, because I have conflicting notes on that.
Well, I guess that's something we need to address. Is he continuing with the plea, or did he want to withdraw the plea? He's been going to treatment while we monitored his progress.
Is his progress okay now, Your Honor? I didn't see the...
Basically, if you want to look at the report, it basically says he's not very cooperative.
Yeah. Well...
He is doing some things, but he's not doing what he needs to do. Is my bottom line on it.
Judge, I believe at least part of that is due to the fact of transportation and him being able to get here from Ashland. He since, as that report notes, moved back to Ashland with the wife.
Because when this began, I think he had South Point address. Is that right?
Yes, sir. Recently, I've been living in Ashland. I've been working there. That's why I requested if maybe I could go to Pathways in Ashland, so I'm closer to everything. If anything, I can just ride a bike there or anything. You know what I mean?
Where are you working?
Arby's now.
In Ashland?
Yes, sir.
What's the state's position on it?
We are prepared to have a trial if we need to. We want him to complete his treatment. If there's been some problem because of the distance or the inability to get there, and the court feels like he ought to maybe go to Pathways, we're not entirely opposed to that. What we would prefer is, because he did plead guilty early on, we'd like to reconfirm that with him and delay sentencing and let him, because of the fact that we've delayed this a pretty good amount of time, in order to give him the opportunity to do treatment. Now, he says he could do it better if he did it in Ashland, so, and I don't know whether Pathways is the best or not. I guess they've been better about sending reports than they had in the past.
They were sending, we had Mr. West, I think is his name, been coming to court some. I mean, I don't have a problem with him going someplace closer to where he lives, but how do you want to proceed, Mr. Moore?
Judge, I'd like to see the man in counseling. Let me ask him a question. Do you want to keep with your plea administration? He does not wish to change his plea, Judge.
Okay.
He does want to go to a counseling place closer to his residence.
Have you been to Pathways before?
Not the one in Ashland.
Okay. Can you get a hold of somebody?
I'm doing it now.
Okay. All right, I wanted to talk with Taylor before he leaves. I'll allow him to switch over to Pathways, which is closer to where he lives now. And I'll also let Mr. West, I'll send him a message letting him know what's happening. Yeah, Randy West. Set the next hearing a month out, September 22nd.
He's going to want you to bring reports, and he's going to want you to be warm and clean.
Yes, sir.
So, see Taylor, and she'll get you the contact information you need to get in touch with somebody at Catholic. And I'm sending them information about your case right now.
So the next hearing is a sentencing?
Yes, it'll be set as a sentencing, September 22nd, 10 o'clock.
Thank you, Judge.
You're welcome.
State of Ohio versus Jacqueline D. Dillon, case number TRD 192682, TRC 172192, A, B, and C.
Mr. Smith's case?
It is my brother's case, Judge. He's in a jury trial in Ironton today. And I was going to stand in. I think we need a date sometime after the 27th of September. The 29th is available on his calendar if that works for the court.
She has something in common, please, too, right?
On the 27th.
Yes,
It's another week.
another week.
Oh, she says it's difficult to go to court twice in 1 week if we could use the following Monday or Friday.
So she does have something in common, please, now, too, right?
According to my brother, she's got another hearing the 27th of September pretrial.
No, it's just a,
Oh, she's in ILC. It's an ILC review. Okay, that'd be in front of Judge Finley then. It's an ILC review. So they'll review that Wednesday the 27th, and she could come the following week on a Monday or Friday. She says with work, it's hard to go to court twice.
October 6th?
That'd be fine, Judge.
Okay, your next hearing here is October 6th.
October 6th, 10 o'clock. He'll be here, Daddy.
So she's still at Bethesda, or is she still at the
No,
library?
I'm just doing, I have a sponsor and I go to Mahajan, but I've completed treatment outpatient, like inpatient and outpatient.
Okay.
However, we'll see then.
All right.
Yeah, sure.
State of Ohio versus William Spalding, case number TRD 23697. William Spalding. William Spalding.
Okay, William Spalding's been called for, has not appeared. He's got 7 days, he called in, said he was in the hospital yesterday, so give him 7 days before warrant issue.
State of Ohio versus Christopher Workman, case number CRB 22614.
All right, Mr. Workman, do you have an attorney?
I didn't, Your Honor. I got laid off and wasn't able to get one.
You want to be considered for a court-appointed attorney?
Not being arrogant, I'm not by far. I don't know that I will need one. What this is a family matter. It's my stepdad, and I think that I'm hoping that we might be able to resolve it without that. And if not,
Is he here today?
I don't see him. And if not, if the man, I love the guy, he's the best dad I know. If the guy shows up whatever that guy recommends, that's what I'll do. I don't know much about court, but I don't know if we'll need an attorney. And if he does show up,
How does the state want to proceed?
We've not been able to make contact with Mr. Yates. If the phone doesn't leave a voicemail, and he hasn't answered, but we do have an address for him of 587 Township Road 148. Is that his address?
that is correct, yes, sir.
So, and I don't know if you can give me a phone number for him?
That's his number, I don't know, but.
744 number?
He knows, my aunt, good family, yeah, and my aunt, my mother lives with him, my aunt's next door. Like I said, if this guy shows up, whatever he recommends, that's what I'll go with, if that's fair.
So we need to make contact with him. We're gonna have to probably do it by mail, and we'll keep trying to call.
Well, I assume you talked to your mother, you might tell him, he's the complaining party, I don't file the charges.
Yes, sir.
The prosecutor does.
Yes, sir.
He complained to them initially, they filed the charge, he needs to get in touch with them, rather than just ignore things, it's not gonna go away that way.
I didn't know if like 3 times, I don't know what his plan is, I really don't, but like I said, 3 times he didn't show up, I didn't know if it got dropped, but if he does show up, like I said, I hold firm on it, whatever he recommends, that's what I'll do.
I'll set it for another pre-trial, how long do you think it'll take to try to get it over?
If we have 2 weeks, Your Honor, that would be hopefully enough.
September 1st.
September 1st.
September 1st will be the next hearing, 10 o'clock.
Thank you, guys.
State of Ohio recalls Alexis Kane, case number CRB 23502.
So I spoke with Ms. Kane. We have a full assessment scheduled for Wednesday at 9, where we'll get her into mental health, help her with her medicating, get her started in services.
Okay. Anything else you want to tell me, Ms. Kane? All right, on your theft offense, I'll impose a $100 fine on court costs. Uh, 30 days in jail, and I'll suspend it on the condition that you cooperate and complete treatment with Bethesda. 30 hours community service. Two years to level 4 probation, stay out of Walmart, and I'm going to set your first review hearing in just a few weeks so I can see how that you are doing treatment, and that you're doing what you're supposed to do. I can't remember if I said this to you, but if I didn't, what I said before, and it's very true, that what's in our community right now is really dangerous. Any drug that you get off the street could have fentanyl in it. Let's see here. And people are dying. Highest overdose, not just here, but it's especially prominent here. The highest overdose death count in the last year of ever. So it could happen. I don't want to see it happen. I want to see you get clean. I want you to have a good life. You can't take drugs off the street. So whatever we got to do to make that not happen anymore is what we need to do. So this is an opportunity for you to get clean and stay clean. And you said you got a 6-year-old? If you need some extra motivation, that should be, man, that's got to be your motivation. They've all heard me say this, but it's true, and I think you need to hear it. You don't want your child to grow up using methamphetamine, do you, or heroin, or any of the other drugs that are out on the street? Do you?
No, sir.
There's no guarantee, regardless of what you do, that your kid's not going to use drugs. But there is a guarantee of this. If you use drugs, your child is going to be more likely to use drugs. If you put them in that exposure, so if you want to increase the chances that your child's going to use drugs, keep using. You just made the odds go up that they will use. That's not my opinion, that's the statistics. So, but your child's young enough that you can, and now's the time to stop it, because you know what the first age usage is for most people that are in treatment around here? It's a lot younger than you think. So 6, maybe he's still full, but it won't be long. You think your child doesn't know you're using? They know what's in the house. They know what you're doing. 6th grade is the first, that's the average for people that first use drugs. 6th grade. It's going to be there, he or she is going to be there soon. So stop it now. Cut it off now. Be the example that you need to be. Okay? I want to see you back on September the 18th for a review hearing. So that's when you're going to come back and I'll get a report of what you're doing. So, and because you have a child, we want to try to do this on an outpatient basis, but you got to make it work. No excuses.
Absolutely.
This has to be top priority. You know, people come in here with crappy excuses all the time why they can't do this. This has to be number 1.
Absolutely.
Okay? All right, we'll see you on September 18th. Go check in with probation, get your paperwork. After that, you're free to go.
Thank you, Your Honor.
You're welcome.
State of Ohio recalls Laban K. Murray, case number CRE 23412, A, B, and C.
So it's after 12 now. And
We have our witnesses.
Oh.
So
Okay.
we intend to have a trial unless Mr. Murray,
Well, I asked that the state speak to the witnesses, which they haven't done before the trial.
our offer is 90 days in jail with 60 days suspended. We want him to serve 30 days in jail. If we have a trial, we're going to want all 90 days in jail.
Okay.
If he's found guilty, which we believe.
Case is set for noon. We're obviously not going to start at noon, but we are going to start today as soon as we get through the other.
Your Honor, I just asked that the state speak with their witnesses.
Well,
I know one of which they have not spoken with.
Okay.
And that's, you know what, that's not any of his business.
It's going to be set for trial, so do not depart the courthouse. We'll call for trial once we get through the other cases that are not for evidence. Okay, we're starting preliminary hearings now.
Well, they wrote statements.
State of Ohio versus Jesse T. Conley, case number CRA 23410, CRD 23907, A and B, CRB 23411.
Mr. Steyer's case set for preliminary hearing and pretrial.
Should and get a suppression motion, things like that.
Your Honor, there is a felony charge pending here. However, there is also an OBI pending, and while usually under those circumstances we don't go forward with discovery, with some discussions with Mr. Heel, he thinks that it would be valuable for us to go forward with discovery and then possibly look at suppression here, which we're willing to do, but obviously I haven't filed discovery up to this point because that's not common to what I do in these cases. So I'm going to ask for continuance to a date that's convenient to the court. We'll waive time constraints to accomplish that, and I'll file discovery and we'll go forward with that matter.
Mr. Heel? Well, typically the state says, well, if you don't want to plead to the OBI, we're going to take it to the grand jury, but this is going to be different.
This, we may end up doing that, but I've reviewed everything, all the evidence, and I believe that this may be one that we either need to try, or Mr. Steyer needs to file a suppression motion the possession charge is a little bit out of the ordinary. So we're willing to give that leeway in this case.
September 1st or September 5th?
5th would probably be better, Your Honor. Let me make 100% certain of that. I'm sorry?
That's a Tuesday.
That's fine.
All right. So
Well, actually, make sure, does Friday versus Tuesday matter to you?
That's whatever you guys
Okay.
need me to do.
All right, September 5th will be the next hearing, preliminary hearing and pre-trial.
Write that down. Especially because it's Tuesday.
September 5th.
Mm-hmm.
What time?
10 o'clock. And don't leave. I'll come out and talk to you in a couple minutes.
Okay.
State of Ohio versus Cody E. Hicks,
Thank
case
you.
number CRA 23392.
This is Mr. Stiers' case, preliminary hearing.
Your Honor, he's compliant. He's completed residential treatment. He has an appointment with outpatient, I want to say, on the 21st. And the wording in that letter is a little weird on the own accord statement. It just means that he elected not to do phase 3. It's something he can do at an outpatient level.
Okay.
And Your Honor, Mr. Hicks spoke to Ms. Dalrymple this morning. I don't see her in the courtroom right now, but she was here earlier. And I believe she thinks he's a candidate for the QRT program, and he does as well.
Okay. She's still here. He's an Ashland resident.
I can get in touch with her.
Oh, here she is.
Okay. She is.
Hello. I did interview Cody Hicks. He signed up, agreed to all terms and conditions, signed paperwork, and his first scheduled check-in with me is September 19th.
Okay. So how do you want to handle, would this be one you want deflected to the QRT or keep it here and eventually dismiss? What he has here is a felony possession, I believe. It's the only charge here.
Yes. If the court is willing to dismiss it to QRT, that would be ideal, but if you want to keep it on the review docket, we're willing to do that as well.
Mr. Hill, do you have a position?
Well, we have faith in the QRT program to keep track of it. We'd be willing to do it either way, Your Honor.
All right, we'll dismiss it to QRT, and then if he is unsuccessful, either they'll take it to the grand jury or refile here, but probably take it to the grand jury.
And each person that I interview, Your Honor, I do explain those consequences to each client.
You understand that, sir?
Yes, sir.
Okay. All right, case will be dismissed to QRT.
Thank you, Your Honor.
You're welcome.
Thank you. Thank you.
You're welcome.
State of Ohio versus Devin Stapleton, case number CRB 23494A and B, CRA 23491.
This is Mr. Stiers' case, preliminary hearing and pre-trial.
Well, just send this up. This is a bench copy. I actually filed a copy with the clerks out there, but made an extra copy to bring up here. I'm filing a suggestion of incapacity to stand trial in this matter. I have been contacted since we were here on Monday by Mr. Stapleton's mother and discussed with her, and I don't actually have it, and I don't know that I can get it. But I've confirmed with him as well that he was in, I can't recall which county, I apologize, in another county, had a juvenile case in which he was found to be mentally incompetent to stand trial. And between the knowledge that he's already been found incompetent by a court and what we've seen speaking to him and speaking to his workers, and several of them are here today, I just don't believe that he is capable of standing trial in this matter. So I'm going to ask that he be evaluated by court clinic. I believe that his service providers would be able to make the arrangements to get him to an evaluation.
Mr. Hill.
Your Honor, there is a felony charge, and it would be, under normal circumstances, we'd want to go ahead and just take it to the grand jury because of the seriousness of the charge. But because of these special circumstances, we're willing to leave it here with a time waiver. And it's also going to be very important for me to speak with the victim and the family of the victim to get their input on it too. I believe that there are special circumstances involved in that situation as well. We want to make sure to do as good as we can to make sure that we don't have further problems. And we do understand that Mr. Steyer has explained about the prior finding that has been in another county.
And Your Honor, I'm in a weird position here. I don't believe that once I have filed the suggestion of competency that I have the ability to waive time constraints. However, the filing of this suggestion of competency tolls time until such time as a ruling has been made on it. So it's one of the, normally I don't mind to go ahead and just sign something anyway, but I think in this situation I'm constrained from doing that.
Okay. That's understandable. And I guess it's possible for a suggestion of incompetency to be filed in municipal court on a felony charge.
Well,
There's still the process that has to go through.
And I feel it's necessary on my part because I don't believe he can successfully participate in a preliminary hearing, nor can I speak to him in a way that I believe I can get a meaningful and knowing and intelligent waiver. So I think that I'm in that position at this point.
Well, as his counsel, I take it that you're not objecting to the case staying here, because the other
Oh, I'm certainly not.
They can just take it to the grand jury.
Right, and recognizing that, I'm not objecting to that, but I'm also actually not taking a position because again, I feel like I'm constrained on his behalf by this filing.
So my concern is, if it stays here, that I want to make sure everybody is safe. As I recall, one of the agreements was I would let him sign a signature bond, and the folks that were helping him would continue to help, and he would agree to allow them to help him, especially with medications and that sort of thing. So, and that he would not have a gun in his possession. I think that was an additional thing that I set forth as part of bond. And I'm not hearing there's been any problems in that area since we allowed him to have bond.
Correct. I spoke to his caseworkers yesterday, and then again this morning, and I've not had any reports of problems. And I don't believe that the entry of the suggestion of incapacity touches bond in any way. I think it leaves bond conditions in place.
All right. Mr. Hill, do you agree with all that?
Yes, Your Honor, and we'll make sure that, I don't know if there's anybody here on behalf of Tally Atkins, or if Stephen Caldwell or Sarah Reed are here. Okay, so we'll make contact with them and get to the bottom of maybe exactly what needs to happen in this.
And September 1st, is that a good date to come back?
We can come back. I think technically the case is stayed by the entry of this suggestion and is really not supposed to have anything else done until the referral's made, and then we get back a report, at which point the court is directed by the statute to set a hearing within 10 days of that. But if we come back before, I don't care to come back before that, but I don't think we can do anything unless the report's been filed, although it may help us keep track of the case.
My thinking on it is just to keep track of the conditions of bond.
And that's fine, Your Honor.
Okay, there'll be a referral to court clinic made, come back September 1st, just to make sure bond has been complied with and there's not been any problems arisen. Okay, next hearing September 1st, 10 o'clock.
Okay.
Thank you.
You're welcome.
You can go on out to the lobby.
State of Ohio recalls James Lewis, case number CRA 23432 A and B, CRA 23433 A and B.
Okay, this is a recall on getting a further report from OVP.
Yes, so she did begin services at OVP in Huntington on the 10th. She was seen there this morning and she has another appointment on the 25th. So far she is compliant and she's doing counseling and she's in the MAT program, so.
Okay, thank you for that report. That was missed a minute. All right, just maybe another month before we come back on a follow-up. Agreeable? So this will be a preliminary hearing, September 22nd.
Thank you, Your Honor.
Okay, be compliant with your treatment.
Thank you.
You're welcome.
State of Ohio versus John D. McCoy, case number CRA 23397, A and B, CRA 22426, CRA 2697.
John McCoy, preliminary hearing. This is Mr. Morford's case. He has an ankle monitor right here.
Clean up the boxes.
Are we at a point where we can remove the ankle monitor or leave it on? He says yes, but I don't know what she says.
Well,
I ain't going nowhere.
Not yet? I've
it's-
removed a lot, well, several times I've removed them, people balk after I've removed them, so.
I mean, I think we can try, I think at this point, he makes his own decisions, and if he wants to risk because we,
What's the state's position on it?
Leave it up to the people who know the best, I guess, the counselors. And hopefully he doesn't do what we fear that he might.
it's worth a shot.
Okay. At some point, you have to own this. And you have to adopt it as your own, I'm okay with initially forcing people to go to treatment, but if that switch doesn't come on, or it's like, this is really what I need to do for me, it's not gonna work long term. It'll only work short term. So hopefully that's happened. You're a young guy, you got a long time to live, hopefully, if you get off drugs. If you don't get off drugs, you might have a short time to live. It's not laughing there because, as I said before, people are dying out there.
Yeah, I won't be
You
turning
don't want
back
to be
that.
one of those people.
I won't be turning back that lifestyle.
Okay, I'll order the ankle monitor removed today, go see Mr. Major about that. Now, if you do leave, then that's pretty much going to guarantee you're going to go down to the other court.
I ain't going nowhere.
So keep it here, best possible end result for you. And we'll come back in another month, September 22nd, and get good reports, and you're on the right path now. Keep it going.
Thank you, Your Honor.
You're welcome. See Mr. Major.
Taking that off. I ain't anyway. Don't worry. Good luck.
Sentencings.
Here, Butch.
State of Ohio versus Brittany Caldwell, case number CRB 131057, CRB 131153, A and B.
Okay, I was going to say, you look so much better now than you did before.
Thank
I was
you.
hoping the report kind of matched the way you look. So, what I'm reading is there's still stuff you're working on, but you're doing a lot better than you were. Because you were creating some havoc for a while.
Sorry about that.
Okay. Now, you look 100% better.
Thank you, I'm feeling better too.
So, you're on board with what I just said, I think applies to you about making this your own, making this for your life. I've got a life. I mean, I want it for you, and it's part of my life in a sense, and I want to see you be successful, but it's not going to change. What happens to you is not ultimately going to change my life, but it's going to change yours.
Right.
You got to adopt it and make it what you want. Okay? And it looks like that's where you're headed. So, anything you want to say, Taylor?
She looks 100% better. I mean, she had a rocky start, but I'm real hopeful for her. Like, I think she knows she can do this.
Okay, Mr. Morford?
I defer to Taylor. I think she looks well, looks a whole lot better than the first time I saw her. And I think she's bought into the recovery, Judge.
Okay, let's do, well, I'm looking at September the 15th, if you're available then, Mr. Morford. Not quite a month out.
I'm here then, Judge.
September 15th for sentencing.
Thank you, Your Honor.
You're welcome.
Thank you, Judge.
You're welcome. Keep it up. You're doing good.
Thank you.
Yes. Okay, court. Okay, so do it.
State of Ohio versus Sarah Osborne, case number CRB 23164A and B.
Mr. Morford's case, sentencing. My notes were this was a case of children's services.
Yes, she's progressed with the case plan, Your Honor, has obtained residence and has been visiting regularly with her children and soon should have custody back.
Great. Good job.
Thank you.
And that is, we confirmed that as well, Your Honor, from Children's Services.
So, how do you want to proceed on the cases?
Well, we'd like to see her complete that, and we'd like to keep this case going as a motivator.
Agreed. Okay. What's the time frame with Children's Services? Do you have one?
Let me see if it says it in the...
Don't.
I think they sent me one in writing. Maybe I'm wrong. Let's see if I've got a text message. I don't have anything on when it might be completed.
Well, maybe a little over a month then.
September 11th, I should be done with parenting, which will start the unsupervised.
Okay.
So, when do you think will be good?
Probably October. I would say if it's not finished, then we ought to have an idea when it would be completed.
October 6th?
That's good here.
October 6th.
Thank you.
And it's a sentence.
State of Ohio versus Carl E. Tooley II, case number CRA 23-345. Carl Tooley II.
I was reading his report on Hunter Tooley, so I've already read it. It's good. Well, after a hiccup, it became good, I would say. So we need to keep going because he's doing really good now, but there was a problem there, right? You left treatment at one point, then you came back, and since then, they're saying you've done really well. Agreed?
Agreed.
Okay. September 29th will be the next one. All right, keep it up. Keep up the good attitude.
State of Ohio versus Jeremy A. McMillan, case number TRC 22-769, A, B, and C. TRC 20-2410, A, B, and C. TRC 14-2341, A, B, and C.
May I approach, Your Honor?
Yes.
They're always on the neck. That's for my surgery, that's cool. I need to explain what that opiates, what he sent to all the surgery.
There is a positive for opiates on there, but he's recently had some major dental work, and that is due to a prescription.
Okay. But since his attitude adjustment program, is he doing better? Or?
He is doing better, and we are working on switching him counselors to, there's some things in the treatment plan that we're working on that has arisen that we want to get worked out. He also came back out without an ankle monitor. Is that going to be acceptable?
What says the state?
I ain't going nowhere, but I'm willing to wear it, however, you want, whatever you want to do, John.
Here's the problem. I think I promised Judge Ferguson that he'd be wearing it.
We better put one on.
I'll hear that at one point.
And I'm in Huntington every day.
Yeah,
So really, I make it a practice not to make any judges who might be able to put me in jail upset with me. So that's a good practice to keep.
I thought it was the original plan of the release from Cal, but I wasn't for sure. I just wanted to.
I think it was, Judge, if I recall, he was going to wear monitors. One of the reasons Judge Ferguson trusted him to.
That's not the pay.
Not that I want to have my client, but I think that you're correct, that was a condition.
So we're going to have an ankle monitor
Better in jail.
placed back on
Don't worry about it.
Okay. He's fine
for a
with that.
while. It's a lot better than, where were you going in West Virginia? You were going to one of the prisons. I don't remember which one it
They
was.
send me back to home prison, it's probably Salem.
Salem? I'm assuming wearing an ankle monitor is a lot better than going there.
Yes, sir. Oh, yes, sir.
So, okay, I think good faith with Judge Ferguson requires that. So I'm going to have an order that you have an ankle monitor put back on and keep working on just not staying clean. You know, Jeremy, you have the ability to do a lot of good things. I'm really proud of some of the stuff that you've done. And we just need to adjust some of your thinking. You need to be honest, truthful, all times. Not
Understand.
not just, well, you don't try to get out of stuff by lying, okay? That's what needs to change, or even help somebody else get out of something behind. That was really bad. So, but you can do this. I'm proud of what you've done. I went out on a limb for you. So I believe that you can do it. I want you to do it.
It'll be done.
Okay, go see Mr. Major, and he'll set up, you get an ankle monitor put back on.
Thank you, Your Honor.
Did you want to come back, Judge?
He's back on the 28th too.
Of August?
Yes.
Okay, yes.
I
Okay,
remember
let's
that
keep
date.
that.
Okay, we'll keep
Won't
that.
change anything.
Thank you, Your Honor.
State of Ohio versus Scott Taylor, case number TRC 222629.
This is Mr. Smith's case sentencing.
Indeed, Judge, may I approach? I have
Yes.
a report from OVP.
Got a report from OVP. Screen's good. Report's good. Well, wait a minute. Now, there's something on us. What is this? Not sure what this means on this second page, 2 of 2.
2 of 2.
I think what we need to do is do a screen here.
Today?
Yeah, let's do a screen here.
Do a screen here, okay.
What I'm seeing there makes, I don't understand it, but
I don't, Judge, I'm just looking at, I don't either.
I think we need a screen here. Let's do a screen here.
State of Ohio versus Heather Rieger, case number CRB 20214.
Okay, you're gonna bring me some records today.
I go back to Dr. Brown on the 22nd to see what they're going to do with my foot. I don't know anything from there. I also brought a thing from my family doctor just showing where he did the orthopedic referral and stuff like that. The other issue is maintained for right now, and they're just going to follow up on that. So there's no current treatment on that, just following up. I would like to say that the reason this has taken so long is when this first started, it was during COVID and they weren't doing community service. And then we had the motorcycle accident and that put me down for like over a year. And I had a stomach surgery. And then last fall is when I broke my knee and everything else. So it's just been one thing after another.
All right.
Thank you.
So when do you think you would be able to do community service?
Like I said, I go back to Dr. Brown on the 22nd. I'll know what's going to happen next, hopefully then.
22nd of this month?
Of September.
Okay, I'll set it for October the 6th as your next hearing.
Is that a Friday?
It is a Friday.
Same time? Or can I, okay. Thank you. Have a good weekend.
You too.
State of Ohio versus Sierra Helms, case number CRD 222711. Sierra Helms.
Sierra Helms has been called for, hasn't appeared. be a warrant issue.
State of Ohio versus Griffin D. Lewis, case number CRB 23469.
You were going to bring me a prescription.
Yes, sir. I have the notes from Kroger. I also brought the bottles, just in case you needed those. Wasn't sure. Let me take what you'd like up there. I did the past couple, Your Honor, just to cover all bases.
Okay. I'll accept that. Anything else you want to tell me before I sentence you?
Yes. I brought documents showing that, I'm in school, and I brought, pay stubs showing that I work. This wasn't something that I would normally do. I'm usually extremely responsible, but I hadn't been doing well mentally. So I had started establishing care with an adult physician because I had been seeing my pediatrician. Where I'm 19, they were still seeing me. And I got on new antidepressants, and I've set up appointments with therapy. My first appointment's going to be Monday. So I just thought I'd let you know because...
Where are you going to school?
Marshall.
Okay.
So I just wanted to let you know that this is not something that I would typically do. It was just a poor lapse in judgment. I think my mental health was attributed to that.
Okay. Since you're a student, I'll make it a $50 fine instead of $150 fine, court costs. 10 days of jail suspended. Order you to stay out of Walmart, 2 years of well-for probation, 30 hours of community service. Set a review hearing for February the 16th of next year. You've got then to get everything finished, which you should be able to do. Not ordering any treatment for the medication you tested for because you have a prescription for it.
Yes, Your Honor.
So you'll need to meet with Mr. Major in his office, the probation officer, and then you're free to go after that.
Would it be at 10 o'clock?
It'll be at 9. The review hearing will be at 9 a.m. It's first.
Thank you, Your Honor.
Major right there, but you're going to go meet him in his office, which is to the left as you leave the courtroom.
Thank you, Your Honor.
Now, out through that doors and then to the left.
State of Ohio versus recalls Bridget Ellis, case number CRB 19820, CRB 18235, CRA 18171, CRB 16133.
I think this was a review hearing this morning. Well, she was supposed to be here on Monday, I think. Okay, she's at Post Source now.
Yes, sir.
She was initially positive for fentanyl.
Then don't do it.
that new drug that's xylazine?
Xylazine, yes, Your Honor.
That's very dangerous too. Wow.
Yeah, it's a animal tranquilizer, I believe.
You probably didn't know you were getting that.
No, sir.
I don't know if people are, probably, I don't know if a lot of people are even getting tested for that, so this is a send-off.
We have some instance that we've gotten that we've been testing on all of our clients, and not too many are positive, but when they are, it's scary.
It's showing up. So back to what I said before, it should add, there's fentanyl and xylazine out in the community that you could get and you don't even know you're getting it. So dangerous stuff. Okay.
Well, that's something ironic, Judge. Killed her brother.
Yeah. Well, we've had a lot of folks here at the court, and some very close to the court, to people that worked here and people I've worked with. So it's no respecter of persons. So the only thing you can do is get clean and stay clean.
Right.
Can't dabble in this. Okay, well, it looks like you're on the right path. You still have outstanding obligations as far as paying fines and costs.
Yeah, I've done 2 days of community service. I do it through them every Saturday, so I can catch up on that, and I have $50 payment today, too.
Okay, see the clerk.
Okay.
I'll set your next review for September 22nd. 9 o'clock.
Thank you.
You're welcome.
Thank you.
State of Ohio recalls Scott Taylor, case number TRC 222629.
Okay, it's an appropriate screen. It's a good screen.
And he said, Bree advised him on that, but they were confused about that page. That's the upper limits it can go up to.
Yeah, I'm not sure. It was very confusing.
It was to me as well, Judge, but he said he would be clean and.
September 22nd, are you available then?
What day, Judge?
September 22nd?
Yes, I'm available, yes.
September 22nd. 10 o'clock.
You do this, Scott. Keep it up.
State of Ohio recalls Donald Dickus, case number CRA 23104, CRA 23105. He's in holding.
Okay, he's in the back and holding cell. We'll need him brought out.
I think there was an error on the screen, and we still strongly are with our initial inpatient. He's unwilling to do that. My concern is that I don't think that jail is going to help him in the needs that he needs. So what we would like to do, and I spoke with him back there, and he seems to be on board, would be to continue outpatient. We're going to increase his level of services, and he knows that if he's not compliant, that we'll be back and he can do the jail time then, if he's agreeable. Things change.
All right, Mr. Dickus is back before the court. He did a urine screen this morning, and there was a mistake on showing positive for cocaine, and now I have a new report. So he was positive for oxycodone, THC, and alcohol. I think alcohol's been the biggest problem. So I'm going to rescind your jail sentence. I'm going to order you back to outpatient, but you got to do better. I mean, you showed up at the last session under the influence.
I had meetings that morning and I drank 3 or 4 alcohol.
Okay, I'll set your next review hearing. Okay, so he's not ordered to jail. He's ordered back to outpatient treatment. And his next review hearing is September 15th. Okay, he's ordered released.
Thank you, Your Honor.
State of Ohio versus Laban Murray, case number CRB 23412, A, B, and C. Laban Murray.
So it looks like we're having a hearing.
Your Honor, I move the court to dismiss this case. Discovery was filed on August 4th. The state has failed to respond. And in the alternate, I ask it to be continued.
We responded, Your Honor.
They did not, Your Honor.
It was actually filed even later than that. I think it was filed on August the 9th.
No, it was filed August the 4th, Your Honor.
It's timestamped August 4th.
Right. Well, on the docket, it says something about August 9th.
It does say August 9th on the docket, Your Honor, but it's filed August 4th.
So, first of all, it filed very close to the trial date. Second of all,
outside the 10 days.
It was, well, I mean, it was still, 10 or 11 days.
Outside the 10 days.
Also, we have answered it. And I don't have it in front of me, but I've seen it this morning that we answered it.
They have not answered it, Your Honor. I have received no answer from the state. If the state has answered it, let me see the answer.
Can you,
And I could have misplaced it, but I'd like to see the state produce the answer.
I don't see it in the court's file.
well, I think we've just done it this morning. And I could be wrong, but I think I saw it first thing when I got here this morning.
Well, they have not served the defense, Your Honor.
We need Mr. Murray in the courtroom.
Yeah, sorry, I thought he would have heard this coming in.
Mr. Murray is in the courtroom now.
I need to know if we filed the discovery answer. That's what I'm asking for.
Let me go find it.
And I believe we did, because I think I saw it in white.
Your Honor, even if the state filed an answer, if they filed it this morning, it's not in the court docket. They have not served the defense. We're set for trial today.
It was just asked for the other day. This case has been pending.
It was asked for on August the 4th, Your Honor.
Pending since the
That's
beginning of
14
July.
days that the state had to respond.
Did we file the discovery answer? Okay, we did, Your Honor. So, and it
What's
was
the
sent
date?
to Stratton on 8/17. So how was that sent to you?
No, I'm sorry. No. No.
You have a,
Resend it?
no,
Or-
do you have, can you confirm that we sent it? Can you go into the email and show that you sent it?
Like the time of that sent, too.
She sent it.
Your Honor, I've checked my
yesterday by email.
August 17th emails. I see no email from the state.
We can give it to him today, and I think we're filing it in plenty of time, given when it was filed, when it was requested.
Your Honor, they're filing it
Well, I mean,
an hour after the trial is scheduled to start.
we had it available, we emailed it yesterday.
You say you emailed it yesterday. I do not have it.
She's looking.
I'm looking at the rule now, Rule 16.
I believe the rule states that there should be a motion to compel to be filed.
Right.
Okay, but that it is still grounds for a continuance.
But it also says, I'm looking for, at time of motion is M, under 16. The defendant shall make his demand for discovery within 21 days after arraignment or 7 days before the date of the trial, whichever is earlier, or at such reasonable time later as the court may permit. A party's motion to compel compliance with the rule shall be made no later than 7 days prior to trial, or 3 days after the opposing party provides discovery, whichever is later.
Sounds like 21 days.
The arraignment in this case was July 7th, so that would have been the end of July. July 28th. Well, here's what I'm inclined to do. The problem is we've got witnesses that are here and great inconvenience to them.
Well, I think it, Your Honor, if I may, I think it gives the opportunity for the state to actually discuss the case with their, if you continue it to another day, it gives the state the opportunity to discuss it with the alleged victim in this case, which I don't believe the state has done today.
Well, here's what I'm going to do. I'm going to take a recess to consider the motion. I'll let you all talk, maybe talk to the witnesses, and maybe that will help resolve things. Okay. Court will be in recess while I consider these discovery issues. Please talk to each other while this is happening.
Thank you, Your Honor.
Thank you, Your Honor.
You're welcome. Mr. Elfin?
Do you have that discovery?
Let me see if y'all, we can, I'm gonna, she's checking her email, but, I'll go ahead. Thanks.
All the water you want?
Huh?
All the water?
No. A little bit stronger than that.
You have a good weekend.
You too, thank you.
Yeah, I'm proud of Boomer.
So what,
Well, we're gonna have to figure out what he's gonna do. He's in a precarious position, so I gotta call the court, I gotta call another court. This wasn't supposed to be going like this.
things not living, anything that's out.
Hey, Debbie, how are you? Well, it's one of those days. Hey, one of those days. It looks like I'm starting a trial out of Chesapeake. So it looks like I'll let people make it back for our pre-trial. So, okay. So I'm going to call motions to continue those. Harry, you had a transport order on, but Harry should be in jail because you were released out of prison on August 5th. So, okay. Yeah. So anyway, I'm only calling motions to continue those two things. Yeah, well, we have a trial on Monday, Judge Harkins, so, yeah, it's not working, it's 2 days, so just FYI on that. All right, thanks, Mike. Always that stuff on top of other stuff, but, so, we'll see what he wants to do. He's just playing hardball for some reason, you know?
Probably because all you're hearing here is domestic violence cases and stuff.
Yeah.
Well, I've never had no violent history or anything like that.
There's that obstruction charge.
I don't even know why I even got that. She didn't even press charges, the sheriff did.
Yeah.
And the sheriff lied on the paperwork. He said that he was scared, so he drew his gun. He kicked the door open. He never knocked. He kicked the door open and then had his gun drawn the whole time.
Okay. I don't even think the officer here, what is it?
You can't even ask. Yeah, the guns never came out my side, man.
Yeah. Just a second.
I just want to go home.
We don't even have an officer.
No.
No officer. It's just those three, that's it.
It's cold in here.
Is that the email sent to me?
Yes, and it just came back at 12:42 today that it
When
was
was it sent?
undeliverable. Well, it was sent yesterday.
Yeah, okay.
It was sent yesterday.
Let me take a look. That's it.
Okay. And then he's got a copy. We'll get you a copy. But it just come back, and that's your address. Isn't that correct address?
That is the correct address.
Yeah, why would it have come back? And it took a whole day to return. That's strange. Because usually you get something immediately.
Where's the original email?
Can
we get the original email?
Okay. Please.
Yes. Yeah. That's my email address. They're pulling something here. Huh?
Why won't they talk to her?
Have they talked to you?
Not since last time I was in court. He said, something that's happened before. I said, no. He said, okay. And then he acted like, you don't talk.
They're only talking to them because
They're trying to scare me.
They're saying that if they get up there and lie, they're going to file charges against them. You probably need to go out there and stand with them. I'm telling you, that they're out there threatening them, that's what they're doing. This is weird. This is weird. This is my email address. This is the email address I've had since 1998. And that's exactly who they sent it to. See, this doesn't make sense. Because,
is there any way we can do like a mistrial or something?
well, I'm asking them just to dismiss it based upon these issues. See, from Microsoft Outlook to my email address, which is correct, sent Friday, August 14th, 12:42. So,
So what's the likelihood of me actually walking out of here?
very good, I believe, very good. Because you got witnesses who are going to testify in a positive manner, especially her. We don't have discovery, so let's start there. That's an issue.
And start with the issue about the cop lying too. Well,
Well, now we'll have to subpoena the cop, and
because on the paperwork, even on the paperwork, it says that there was nothing wrong with it. It was just red of the face and that's screaming.
Okay. There's been some kind of mix-up. I sent it yesterday with the attachment. That's what Bill has. I printed a copy of it. But then today, I received this at 12:42 while you guys are here, and it was being asked. This. 12:42 today said undeliverable. So I went and checked your email. It is all correct.
it's
This
the
is what I
same
got.
email that's been available and used since 1998.
Exactly.
It's the same email.
Is it not, it's correct here?
It is very correct.
Okay, so why did I receive this today, right now, 12:42, but yet I sent it
It was
yesterday?
the same time as this.
Is that not? That's your email.
It is.
So that's what I have. I attached it. He has a copy of it. That's where it says that. I don't
It's
know.
not good delivery. What's yours? Did you get a copy of that discovery?
She was making it to give to him. Yeah, I'll go ahead, get it going to have it next.
I don't know why he plays hardball on these things like he does. He does this every once in a while. There was one case where we had it on a veteran who had PTSD, who was in jail. That he just kept in jail, kept in jail, kept in jail. It just happens at times. It's just full of shit sometimes.
I'm just saying, man, I can't go to fucking jail, dude. I got a fucking 2-month-old baby, dude. I got 2 other kids. This has never happened before in my whole life, man.
Well, so on a DV, by the way, you'll be the first one that I know of he's asked jail time on. So,
But for what reason? What did I do so wrong?
because he's like that. He's like that. He thinks he's doing that stuff in the interest of justice. It's not the interest of justice that he's doing. You know? He makes every excuse under the book for what doing things different.
Like ever since the start.
Because you had a
of
gun on your side, you know? And we gotta be careful what we talk about here. That, of course, all this says. You need to, so take a look at these, all right? So this email is correct, okay?
So what is this?
This is supposed to be discovery that they were supposed to send me. So they sent it, said they sent it on August 17th, which was yesterday at 12:42. And said they got this back that said it's undeliverable August 18th at 12:42. Where's the message? And this email's correct, so.
So what is a discovery?
It's the evidence in the case.
Okay.
Police reports, whatever there might be.
Okay, and then So this is a different one from that one, right?
Yeah, they said they sent it, and then they got this back saying it was undeliverable.
But why does this look like this, but this one looks like this?
I don't know. It says there was an answer attached. There's no way. Wait, it says domain of sender address does not resolve. That's the sender. That's a sender issue. Let me see here. I don't think I've ever seen this. I mean, she sent emails before.
But that's just the only one that you never got. So what happened since they don't have that? Or since everything's messed up with it? It just depends on what he wants to do.
I mean, no, he should continue at the very least. And, so what's her name? What's her name? So that's the same email address that you sent me discovery
Yes,
before.
yes, and I was
And
gonna ask you
it
if
has nothing to do with me.
No.
Because right here it says domain of sender address does not resolve. That's a sender issue.
That's the email I have.
Domain of sender address
Yeah, I'm due for it.
does not resolve. This is a sender issue, this is not a recipient issue. There's nothing wrong with your server.
Not that I'm aware of.
That's what it
That
says.
says it's not, does not resolve.
Yeah.
This is a copy of what I sent.
I mean, it's a sender issue.
Okay. You see.
Peyton Marbury? Is that who's out there?
Yeah.
Stated that she was woken up by loud screaming and bangs. Stated that she went into the living room to see you hitting my sister repeatedly. She said she went out for a while and then tried stopping it, but it only made it worse. He had a gun on his hip and told her he was going to shoot her and then kill himself.
Bro. And I didn't hit her, and she never tried to stop anything. Because the only thing that made everything worse is I walked into the kitchen and was like, why don't I deserve the respect to leave too? I looked at her dead in her eyes and I was like, don't I deserve the respect to leave too? She said yes. the whole time I was being arrested, the only thing I kept saying was I was just trying to leave because that's all I was trying to do during this whole fight. I was trying to leave.
Frank was physically fine, other than some reddening on her face, which is probably the result of her crying, which it says up here that she was crying and stuff. But I explained that she was woken up by Marbury knocking on her door because her sister's boyfriend's being married. So here's Michelle Murdoch's statement. I woke up to Peyton knocking on my door because her sister's boyfriend was beating on her and she wanted me to call the cops. I walked out on my porch and I could hear them screaming and the guy had a gun also. Then cops showed up. Who came?
Peyton apparently knocked on the door.
Started as just bickering back and forth because I was aggravated, stressed out, and overwhelmed. I just had a baby, so I hadn't been getting much sleep. And when I asked him for help, it came out sounding like I was calling him a bad parent rather than me asking for help. So he wanted to leave, and I didn't want to stay here by myself. At that point, I just was ready to go home, but our argument was just out of hand with us screaming at each other.
See what I mean?
I was sleeping with my son and got woken up to screaming a loud bang. As I came into the living room to see him hitting my sister repeatedly. It went on for a while. Tried stopping it, which made it worse. He had a gun on his hip and told her he was going to shoot her and then kill him.
See, she's going off what Peyton said. She is not even a witness because by the time she came outside, the cops were already there.
Well, what about Peyton?
Peyton was the only one in there.
Okay. This is the same thing that's over there. Then the obstruction. Where's the obstruction come from? The obstruction is probably right here where.
Because he said I went down and reached for my gun, like I turned and reached.
He didn't say that. The male moved his right hand towards his waistband. That's not necessarily moving towards your gun. Okay. That's just moving.
He said I drew my sidearm. His gun was pointed because he kicked the fucking
he
door.
drew his sidearm.
Yeah, that's what I was saying.
Okay.
He already had it drawn. He kicked the door in.
Yeah, drawn and kicked the door.
And then he told me in the car that he was going to shoot me.
Are you ready?
Well, wherever Philip's at.
Okay, well, I'm checking with both of you to see if you're ready, so that's.
I'd like to go back to chambers.
Well,
The judge.
well, the judge still got some people back there, but I'll give him the message that you'd like to visit in the chambers.
Yeah, we should talk. This prosecutor, okay, I seen this prosecutor keep veterans in jail just to be an ass, okay? It's disgusting what he does sometimes, okay? This is not justice, okay? A prosecutor should work towards justice, okay? This is not justice.
Dirty word.
And the last time I've been through this with him was over a veteran. Somebody who had PTSD, somebody who was a hero, okay? And he just because he can, okay, under some theory of, well, I'm looking out for other people. No, you're not. No, you're not. You're just drunk with power.
So what do you think he's going to do when Claudia tells him that nothing happened? So how do you think he's
Well,
going
there's conflicting stories. I don't know. We'll see. We'll see what he says. He's gonna come in here and try to BS his way through it. Okay. I'll be right back. go someplace else where we don't have this. So he's going to rule against my motion, continue on my motion to dismiss.
The Philip's still out there, and he with his client, and they must be talking about some kind of. Yeah. This has also been going on for a while, the bitterness between Stratton and Philip too.
I've seen.
Yeah. No, no. Oh, he just goes. I know.
Short view.
Yep.
And you know what? I know not doesn't give you any.
No, it won't. It wasn't.
He's not here much, hardly ever see him. What's his name?
See, I know that.
I've heard him one day, we were in the conference room, and he was, and it was nothing for him to use filthy language all the time, and I thought, don't you know any better than that? You're in a court of law.
Yeah.
Whether you're in the conference room or not.
Yeah, I mean, you know, I understand you may use a little dirty language now and then, joking around, but not when you're.
No, but I mean, it was, we were, no, I'll tell you where we were. I think we were in the prosecutor's conference room in Ironton when he first started coming back here. And I was just appalled, you know, and there was a lot of people in the room, a lot. And I thought, don't you know any better than that?
Yeah, that's.
You went all through law school and military, and you don't know any
You don't
better.
know, yeah, I mean, yeah, come on. Yeah,
Whatever.
yeah, in the military, if your superior will use like that language, it was okay, but don't you dare use it because you'll be in big trouble.
Yes, exactly. You know, I was going to make sure Jackie knew, because she was on that reunion committee with Kathy Lawson. Did you hear about Kathy?
Yes.
Well, she's some better.
Is she better?
Yeah, because Sandy has been going every day, because they're best friends. They finally got her off the ventilator.
Oh, good.
Yes,
Yeah,
yes.
Jackie, we good to know that. I don't think
Yes,
she-
tell her
I'll tell
that. They got her off the ventilator, and now yesterday was I think it was like 2 days ago.
Okay.
But yesterday was a really bad day. Sandy was over there a lot during the day, and then she went back yesterday evening.
Well, what caused her?
She had an aortic aneurysm.
Okay, yeah, I've heard that mentioned.
Yes, and
I mean, you're very lucky you didn't die.
she's lucky she's alive.
Yeah, I mean,
That's what Sandy told
that's
her.
fatal a bunch of times.
Yes.
A large percentage of the time.
Right. That's what they said, and the surgery was very lengthy. Well, she began to get sick late Sunday afternoon, and I don't know how much time lapsed, but she called her daughter maybe 4 o'clock and told her that she was really sick, and she was going to
take herself to the hospital. And her daughter told her, no, Mom, I'll come and get you. Of course, she doesn't live very far from it. And she said, I can take myself. Well, her daughter did come, and Kathy was in her car backing out of the driveway, but almost double, bent over in pain. And her daughter got her and got her to the hospital, and they didn't waste any time taking her to surgery.
Who did her surgery?
I heard him talk about him, the surgeon, and Sandy said he's been marvelous and kept them very informed. And
So her husband?
she's in St. Mary's.
St. Mary's?
Yeah.
Yeah, that's,
Yeah.
they've got some really good heart surgeons there.
And they have been a heart center for a long time. But you know, I remember when my dad was in the hospital, and this has been 25 years ago. No, I can't remember. He died in '06, so it was 4 or 5 years before. But he was in the hospital, Ron, 5 months. He was in intensive care 3 months.
Wow.
But I'm going to tell you, Dad had open heart surgery, and he had 3 different surgeries. But the doctors told us he was strong enough, health-wise, to withstand that. Anyway, when he went in, they did all the surgery. Well, and they come and told us he did fine and all that. Well, when they tried, and that's when Dr. Setzer was still there, and Dr. George. And when they tried, they could never, we kept saying, we went into the recovery. They let us go in to see him in the recovery. And we thought everything was fine. Well, they never would take him out of recovery. And several days goes by, and he's still in recovery.
That's unusual.
And so they said, there's a problem, there's something wrong, we don't know what it is. We've checked everything, but he's taken a turn for the worse. And a few more days go by, and they came and told us, we're going to have to go back in and see what's wrong. We can't find anything wrong. So they did that, and they said, now, the possibility he may not survive. Ron, it was a roller coaster. And so they did that. Well, after it was over, they came back and said, well, we couldn't find anything that's causing this problem. They couldn't find anything, and they went on and on. Finally, and then weeks, he got worse and worse, and they kept him in intensive care. Weeks and weeks. I mean, probably a month, and they finally came. And I remember talking to the doctor, and I asked him, have you given up? Do you think it's not? He said, no, I have not. We do not. The next thing we know, he's in bed, and he stayed in his room the whole day. He changed all the IVs. He did everything. In the meantime, that's huge. Just his own. And so, but anyway, and we were scared of that. It just, and finally, Dad was pushing to the head.
That's what's causing the problem.
It was,
Yeah.
yeah, that's rare.
Yeah.
It's very rare.
Yeah.
You might as well stand up.
That happens.
Stand up when the judge comes in.
No, I don't think they did. I hope they didn't. Yes, they do. Excuse me.
Sure you don't want to do this obstruction charge, maybe, and suspend the time.
No, we do the domestic violence charge and argue sentencing.
Oh, geez, Philip, I don't know why you push these issues. You know the standard's beyond a reasonable doubt, don't you?
I do.
Lawrence County Municipal Court is now back in session.
You can be seated.
Thank you, Your Honor.
Okay, this is Levon Murray, 23-412, set for trial, and we're going to go forward with trial. There was a motion to continue made by the defendant. I'm denying that. I find that the discovery request was not followed in the time frame required, so we're going to go ahead with trial today. Mr. Hill.
Your Honor, if it please the court, what we're going to present today is what we consider to be a very serious...
Your Honor, am I entitled to a jury trial?
You are not.
Thank you.
Your Honor. Go ahead.
I believe there was a jury demand filed in this case.
August the 4th.
Within 10 days of a trial date.
Okay, I'll look at that. It wasn't raised until just now at the start of the trial. Okay. This was set for a jury trial on July 21st, according to the civil, or to the criminal rule A, 23A. You must make a demand. You can make it 10 days prior to the date set for trial, or 3 days after the notice of the date set for trial, whichever is later, so. Okay, well, he's filed it within the time frames.
The state still wants to negotiate and see if we can resolve this matter today back in chambers, we can, or back in conference.
Okay.
Because I believe there's a resolution to be had here. The state, I don't believe can make it.
I cannot force that, so
Yeah,
you guys talk some more, and if not, then I'll rule on your request for jury trial. So, court will be in recess while you talk, and then I'll come out. If you can't resolve it, I'll rule on the request for jury trial, but it appears to be, and I can't believe that's the rule, you can make it as late as 10 days prior to the trial date or demand for jury. Okay, court's in recess.
I have epilepsy and it's in medical records too.
Do you have a card?
I do not have a card, sir.
Okay. date. So this will be the pre-trial, be 9/8. Okay.
Lawrence County Municipal Court's now back in session.
Okay, you can have a seat. Where's the witnesses?
They went outside, sir.
Okay, let's get them in here. They need to hear this.
Yeah, go get it.
Okay, we're back on the record on Murray, case number 23-412. There was a jury demand filed by the defendant in this case on August the 4th. That's 14 days ago now. And there was a request for a jury trial today. That's the first time it's actually been brought to the court's attention. The written demand was made on August the 4th. It's never been discussed until today. But, and my inclination would be, if I made the rules, I would deny the request for a jury trial and we go ahead and have a trial today. That's what I want to do. But I've taken an oath to follow the rules, and I don't get to write the rules. And there's rules of criminal procedure in Ohio that are, I don't know if they're written by, but they are approved by the Ohio Supreme Court, and I have the duty to follow those. And Rule 23 says that a defendant in a petty case, which is considered a petty case because it's not a felony case, you can't go to prison for this. You can only go to the county jail. That makes it a petty case. Can make a demand for a jury trial within 10 days of the trial date. Well, it was made 14 days ago. So I have to give them a jury trial, which is kind of crazy because there's no way to get a jury in here in 10 days. Even if I looked at it and said, okay, we need a jury here, we can't get a jury in 10 days because there's a bunch of hoops you got to jump through to get 30, 35 people subpoenaed to come in to form the jury. That's about how many get called to try to get enough folks in here to get a jury. So making an explanation so you understand why I'm ruling the way I am. Reluctantly, I really don't want to do this, but I feel like I'm required to continue the case because the defendant did ask for a jury. He did ask for one in a timely manner under the rules. So what I'm going to do then is I'm going to set it for a jury trial September 20, I think I'll make it the 29th. Are you available then? Because we need more than 2 weeks probably for the clerk to get everything together and get.
Yeah, the 29th.
29th works?
Yeah.
For both? Okay, I'm going to set it for September 29th to commence at, we'll say 1 o'clock because there's no reason to have people come in and middle around because a lot of times the court is still going on at noon. So 1 o'clock, it'll be set for a jury trial on September 29th. And it will go into the next day, which would be hard to get done in one day, a jury trial. So it goes into Saturday if we don't finish on the 29th, which would be the 30th. I am going to set a pretrial. What did we say, the 8th?
The 8th, yes.
So that's 3 weeks before. That's a better time frame. We'll lead time to get a jury subpoenaed in here if we need it. So there'll be a pretrial on September the 8th at 10 o'clock. It's my understanding there's been some things discussed between the state and the defendant that may happen between now and then that could make this case more likely to be settled by an agreement versus going to a jury trial.
Correct, John.
But we do have the jury trial there, and we'll have enough time to get one in here if you all don't reach some sort of arrangement. So,
that's right.
Now, the witnesses that are here, I'm apologize to you for being brought in here today, and then you're not going to get to testify. And I hope you understand the reason I feel like I have to continue it because of the jury demand that was filed in a timely manner. And we don't have a jury here to hear the case. But so that if you are needed, can you give an address on the record so you can be subpoenaed to appear at the jury trial if the case is not resolved? And we've got, I believe,
Peyton Mabry is the first one.
Peyton Mabry. Is that you, ma'am? And I've got 248 Township Road, 1026, South Point.
Yes.
That's the correct address for you?
Yes.
Do you have any questions, ma'am?
No.
Okay. Michelle Murdoch,
Yes.
242 Township Road, 1026.
Yes,
You guys must be neighbors.
yes, right in front of me.
Okay. Claudia Crank, same address as Peyton, 248 Township Road, 1026. Okay, wrong. What's your address, ma'am?
1861 Fifth Avenue West, Huntington, Virginia.
Okay, did you get that?
1851 6th Avenue West.
6th or 5th?
It's 1861 Fifth Ave West,
5th Avenue West.
And the zip code?
25704.
Your Honor, is it possible for subpoenas to be prepared for them so they can receive them before they leave here? I don't know if that's possible or not.
Yeah, we could do it. Okay, anything, Mr. Stratton, anything from you?
Nothing further, Your Honor.
Anything further, Mr. Hill?
Well, Your Honor, I would like to say that, well, we've discussed, I think, some issues that might help us resolve things at the pretrial. So we'll get those done.
Yes, Your Honor. All right, court's adjourned.
Will I need to be with the next set of trial things that's going on?
Well, he's the one that wants you here, so you need to talk to him.
I don't think that I know.